Yes.
I think mention hearing 21 to 51.
21 to 51.
Please, Your Lordship. Lordship, my seniors in bereavement, so I pray.
31 to 51.
Yes, 51, Your Lordship.
Yes, what do you want?
Lordship, my seniors in bereavement, so I pray this matter may come up on 13th of May.
On the request of the learned counsel, so what is your name? You tell him the name.
Because of
The matter stands adjourned today, based on 13th
13th of May.
13th of May.
14 to 16.
14 to 16.
Lordship, can you bring 2 weeks time to file a reply?
You want to file affidavit?
Yes.
14 to 15, the learned counsel, MS so-and-so, submits that she needs some time to file the necessary affidavit. The query is allowed. When do you want it?
3 weeks.
Least up to 3 weeks.
Wait, please. Also.
Yes.
I'd like to mention item number 26 to 30. What to hearing this lodge?
26 to
26 to 30 lodge.
36 to 30.
26
Or 26 to 30.
30 lodge. I'm for respondent number 6 in this case, lodge.
Yes.
I filed an affidavit in the month of March, lodge. However, on perusal of the affidavit, lodge, there are certain rectification required, lodge. If I may be allowed to file an IA, lodge.
Okay. The learned counsel, Mr.
More Jamil, lodge.
appearing for respondent number 6 submits that he had filed an interlocutory application.
I filed an affidavit, lodge. An additional
He
affidavit.
has filed an additional affidavit, which has some errors in it. Therefore, he wants to file an interlocutory application
Yes.
to correct those errors.
Lodge.
The learned counsel prayed for some time. I have also heard Mr.
Josh Worship.
Learned government advocate
No, Lordship, I'm for the petitioners.
for the petitioners. The prayer of the learned counsel is allowed at least up to 2 weeks.
Lodge. Obliged, lodge.
Bless you, Lordship.
Lodge. I also back to mention item number 52, lodge.
52.
Yes, lodge.
Yes.
This matter may be listed after a week, lodge.
You are the
I'm for the petitioner, lodge.
petitioner. The learned counsel so and so appearing for the petitioner. Prays for an adjournment. The prayer is allowed after 2 weeks,
Lodge.
at least after 2 weeks.
Much obliged.
Your Lordship.
Yes.
Your Lordship, I'd like to mention item 22 and 23 from the hearing list, Your Lordship.
22
I'm
and
mentioning on
23.
behalf of my colleague who is appearing for the state, Your Lordship. This matter may be passed over for a day, Your Lordship.
Okay.
22 and 23.
On
She
the,
has some-
on the request of the learned counsel so and so. Tell your name.
Livika, on behalf of Livika, Your Lordship.
The matter is
She's appearing on behalf of the state.
on behalf of the state. The hearing is adjourned today. I have also heard Mr. You are for the
Petitioner.
for a petitioner. I have also heard Mr. So and so appearing for a petitioner. List up to 2 weeks. When do you want it?
Your Lordship, pass over for the day. It may be listed tomorrow, Your Lordship.
Tomorrow it will be difficult.
Okay, Your Lordship.
List next week.
Your Lordship, also item 24, Your Lordship, of the hearing list, Your Lordship.
Yes.
This may be fixed on Thursday, that is 25th of this month, Your Lordship.
Okay. On the request of the learned counsel so and so, the matter is adjourned today. List on 25th. You are for the?
And for the petition.
I have also heard MS so and so appearing for the petitioner.
Yes, but to this item. Your Lordship, I also beg to mention item 6, Your Lordship.
6
This may be listed next week, Your Lordship, for admission hearing, Your Lordship.
for admission hearing.
Yes, Your Lordship.
You are for the petitioner?
I'm for the petitioner.
Or you are for the petitioner? On the prayer of MS so and so appearing for the respondent, the matter is adjourned today. I have also heard the learned counsel MS, what is your name?
Rubika.
Appearing for the petitioner. List next week.
Your Lordship, a similar prayer for item 10 on behalf of Livika, Your Lordship. This may also be listed on 25th Thursday, Your Lordship. Item 10.
Okay, on the request of the learned counsel MS so and so, the matter is adjourned today. List on when?
25th, Your Lordship.
25th. April.
Much obliged. Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 4, Lordship.
Hmm.
On behalf of Vijana, Lordship, if this matter can come up after 1 week. Item 4,
You are
for the state, Lordship.
for the state.
Lordship.
On the request of the learned counsel so and so, what is your name?
S. Chang, Lordship.
Paying for the respondent state, the matter is adjourned today. List next week.
Lordship, I also beg to mention item number 5, Lordship.
Hmm.
On behalf of Vijimoni, Lordship.
Hmm.
Kindly grant me 3 weeks' time to file my counter, Lordship.
You want to file counter affidavit?
Lordship.
Lordship, on the last occasion, this honorable court was kind enough to pass it out. Which stated because they had failed to file the reply within up to more than 3 years. So the court directed that on the failure to file any reply by the state, the court will be, the matter will be taken up based on the reports available.
I'm giving one last chance. The learned counsel so and so, wait for some time to file a counter affidavit. The learned counsel, your name is?
Matushi, petition number 1 and 2.
Appearing for the petitioners 1 and 2. Limatoshi. I Limatoshi. Appearing for the petitioner objected to it on the ground that sufficient time has been taken by the state to file the counter affidavit. After hearing both sides, one last opportunity is given to the state respondent to file the counter affidavit. List after 2 weeks.
Lordship, I also beg to mention item number 8 and 9, Lordship.
Hmm.
On behalf of Jimomi, Lordship.
Yes.
I'm yet to receive instructions, Lordship, so kindly grant me 3 weeks' time, Lordship.
Okay. The learned counsel so and so, MS so and so appearing for the state respondent, raised for some time to file. Oh, you are for a petitioner. You are for Jimoni. A Jimoni. You are appearing.
Vijimoni.
Wait for some time to file, or wait for some time to take instructions. I have also had MS. What is your name? Appearing for the petitioner. The prayer of the state respondent is allowed. List after 2 weeks.
Lordship, I have similar prayer for item number 17, Lordship.
Hmm.
On behalf of Mo Injin.
Yes.
Kindly grant me 3 weeks' time, Lordship, to file my counter.
You are for the respondent.
Lordship.
On the request of the learned counsel so and so, the matter is adjourned today. I have also heard you are for a petitioner.
Yes, I'm for a petitioner.
I have also heard MS. What is your name?
Vitere.
Appearing for the petitioner. List after 2 weeks.
Lordship, I have item number 54, Lordship, hearing item. If this matter can come after a week, on behalf of Mo Injin, Lordship.
On the request of the learned counsel so and so, the matter stands adjourned today. List after 2 weeks.
Obliged, Lordship.
May it please your lordship.
Yes.
I beg to mention item 53 on behalf of my senior, Mr. Gauhati. On the consensus prayer of both the party, I pray that this matter come up on Thursday.
You are for a respondent.
Respondent is
The learned counsel MS.
Asikiri on behalf of Gauhati.
Appearing for a respondent, praise for an adjournment. I have also heard you are
TB Jamir, Lordship.
TB
I'm
Jamir.
for a petition.
TB Jamir, appearing for the petitioner. The hearing is adjourned today. When do you want it?
Thursday.
Lordship, if it is convenient, on Thursday, your lordship, 25th,
Okay, on 25th.
obliged.
Your lordship, I also beg to mention item 25 on the consensus prayer of both the parties. Let this matter come up on after 1 week.
My lord, will it be convenient for your lordship to list on 29?
On 29th.
29.
After hearing the learned counsels of both sides, the matter is adjourned today, list on 29th April.
Much obliged.
Your Lordship, I also beg to mention item number 20. Here we are yet to receive instructions, so 3 weeks time may be given to us.
The learned counsel MS so and so appearing for the petitioner, prays for some time to take instructions. I have also heard MS.
Limika for the petitioner.
Limika appearing for the petitioner. The matter is adjourned today, list after 2 weeks.
Obliged.
Yes, Lordship.
Yes,
Lordship, I beg to mention item 13.
1-3.
Yes. I'm referring for the private respondent here, Lordship.
Yes.
Lordship, bleedings are completed in this case, Lordship. So may I read that this matter listed for regular hearing, Lordship,
For
in
hearing.
usual course.
Heard the learned counsel, Mr. You're for a petitioner.
Yes, I'm for a petitioner.
You're for a petitioner. Heard Mr. What is your name?
Hisinglo.
Single low. Appearing for a petitioner. Heard Mr. What is your name?
What is your matter?
What is Jamil? What is Jamil?
Yes.
Appearing for the respondent. Pleadings are complete. List for hearing in due course.
Obliged.
I
Yes,
beg your indulgence, Your Lordship. There's an interim order in item 20.
20.
Yes, Your Lordship.
20 is already adjourned.
Yes, Your Lordship, but there's an interim order, so if we
For
can continue.
item 20, the interim order passed, let's continue.
Much obliged.
For motion, item number 1.
Yes,
May I please, Lordship?
yes.
My lord, the petitioner herein is praying for a direction from this honorable court to direct the state respondents to regularize the service to regularize his work charge service as per the office memorandum dated 17 March 2015. The petitioner herein was appointed on 7th February 1994. And by 7th of February 2024, he has completed his 30 years of service. And there is an office memorandum of 17 March 2015 by which it says that those work charge or casual employees who have completed 30 years of service will be considered for regularization. As such, the petitioner has also submitted a representation on 4th of March 2024. So, my lord, the grievance of the petitioner will also be addressed if this representation is if a direction may be given to the state respondent to dispose of this representation within a short period of time, my lord.
Who is for the state? Yes. You want to say something?
No, Lordship.
You want only that much?
Yes, my lord, the grievance of the petitioner will be addressed because I have already submitted the representation on 4th of March 2024. So if a direction may be given to the state respondent to dispose of this representation as per the office memorandum.
Where is the office memorandum?
My lord, it's in page number 17, my lord.
17.
Yes, my lord. May I read it, my lord?
Yes.
My lord, office memorandum dated 17 March 2015. Scheme for regularization and absorption of work charge in casual employees and revision of pay / wages. On due consideration of the report of work charge in casual employees commission and in compliance with the judgment in order of the Honorable High Court, the government of Nagaland is pleased to introduce the following scheme for regularization and absorption of work charge in casual employees and revision of their pay and wages subject to conditions indicated herein under. Number 1. All existing work charge and casual employees of various departments who are enjoying scale B and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their post into regular ones, personal to them, and subject to fulfillment of the conditions as indicated below. Number 8. The incumbent concerned of and his or her service rendered as work charge or casual employees have duly been verified and found genuine by the district level verification committee constituted by the government. Number B, availability of service reports including appointment order, date of initial appointment, proof of length of service, etc. Number C, their suitability for continuation in service to be recommended by the head of department concerned. Number D, the post occupied by them on regularization shall automatically stand abolished as and when they vacate the post on retirement, resignation, death, etc. The strength of the work charge in casual employees under various departments shall stand reduced to equal number concurrently with the regularization of such employees. No fresh appointment shall be made against this post. Number E, on regularization in service, the pay of the incumbent shall be fixed at the minimum of the corresponding pay band and grade B as admissible under Rule 10 of the Nagaland Service ROB Rules 2010. My lord, the relevant portion is page number 18, clause 2.
Clause 2.
Yes, my lord. Which will be the third paragraph. In respect of those work charge in casual employees in scale pay who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization will be taken up subsequently in 2 pages as on 1st July and 1st January every year. The procedures and terms and conditions will be the same as laid down in this office memorandum. So this covers the petitioner's case also.
All right. Third, the learned counsel, Mr.
Takatuchu.
Takatuchu, appearing for the petitioner, RDMS. I forgot your name.
S. Chang, Lordship.
S. Sanu. Appearing for the state respondents. Here. This is an application under Article 226 of the Constitution of India. Praying for a direction asking the state respondents to consider his representation for regularizing his services in the Public Health Engineering Department, Government of Nagaland. When he was appointed in the service,
7th February 1994.
on 7th February 1994, the petitioner was appointed as a work charge chokidar in the Public Health Engineering Department, Government of Assam, Government of Nagaland.
Subdivision Futsuro.
Huh?
Subdivision Futsuro. Public Health Engineering Department, Subdivision Futsuro.
Subdivision
Futsuro.
Potsulo. Since then, the petitioner has been serving as a work charge chokidar. He has completed 30 years of continuous service. Here. On 17th March 2015, the state respondents issued an office memorandum number AR-3/GEN capital -2001 stroke 2009. Stop. Through this office memorandum, the state respondents have decided to regularize the services of the casual employees,
Work charge.
work charge employees who has completed 30 years of continuous service after 01/01/2015. Stop. On the basis of the said memorandum, the petitioner filed a representation before the authorities, and the said representation is not yet considered fair. After hearing both sides, it is hereby directed that the state respondents shall consider the representation filed by the present petitioner within next 2 months of receiving this order and shall pass appropriate order.
My
With the
lord.
aforesaid direction, the writ petition stands disposal.
Item number 2.
Yes,
Mr. Lordship,
yes.
petitioner here approaching this honorable court for praying for cancellation of praying for quashing and setting aside of the cancellation of their land patas, Your Lordship, and eviction order as well as restraining order, Your Lordship. Here, I may be allowed to state the brief fact of the case, Your Lordship.
Yes.
Lordship here, the petitioner is the owner of a plot of land. And here in Kohima at New Ministers, Your Lordship. So having right title and interest, Lordship, the petitioner have constructed permanent structures and have been living peacefully since 2010, Lordship. Here, this plot of land was bought from a person, Lordship, from a private individual, and have already executed a sale agreement, which is already authenticated by the revenue cum settlement officer, Lordship. And then in the meantime, the petitioner has also submitted for land pata, which eventually the land pata was given, Lordship. Here on 16/6/2023, Lordship, 16/6/2023, Annexure F, Lordship, Annexure F, page number 30.
Page number
30, Lordship.
30.
Yes, Lordship. On 16/6/2023, Annexure F, the petitioner was given restraining order. Restraining order to this particular to this land, stating that you are illegally encroaching and undertaking construction activities within the Honorable Judge's bungalow at Minister's Hill. Therefore, you are hereby directed to restrain from undertaking any construction work within the said site immediately. Further, you are asked to submit land documents within 15 days from the receipt of this order, failing which legal action shall be initiated against as per provision of law. So likewise, Lordship, the petitioner has given his reply, stating that it's a private land and he has already bought this plot of land from a private individual who was the actual landowner, Lordship, and so has prayed to recall the restraining order. But however, in the morning of Lordship, in the morning of 29/11/2023, Lordship, the petitioner was shocked to see the revenue officer and then 5 to 6 dobashes and police personnel outside his premises, forcing him to vacate the premises immediately. But the petitioner replied that he did not receive any of the notice. And so on further questioning, the revenue officer, he stated that to go and collect before the deputy commissioner office, the notice. And so what happened on the same day, the petitioner immediately went forward to collect the eviction notice, Your Lordship. The eviction notice is at page number 35.
Yes.
Lordship, I may be allowed to read, Lordship. Whereas notice under section 6(1) of the Nagaland Eviction of Person in Unauthorized Occupation of Public Land Act 1971 has been issued to you by letter even number so and so in connection with illegal encroachment and undertaking construction activities within within the Honorable Judge's bungalow at New Minister's Hill. And whereas you have not complied with the notice order to vacate, evict from the said bungalow within the stipulated time, therefore it is necessary to evict such unauthorized illegal occupant from by the government. Hence, in exercise of the power conferred under Section 8(1) of the Nagaland Eviction in unauthorized occupation of public land, Sri Kumar Ramlikan IAS hereby order the illegal occupation of the government land at New Minister shall be evicted by using necessary force. The cost for execution during eviction shall be borne by the evictee. Lordship, here the order, this eviction order was passed jointly against these two petitioners. Lordship. Lordship, having no choice, since the eviction order, this order was received lately. So having no choice, the petitioner approached this honorable court. So
You are evicted or going to be evicted?
Lordship, here, what happened was, after approaching this honorable court, this honorable court has directed the petitioners that there's an option under Section 12 of the Eviction Act to file for an appeal. And so likewise, in compliance of this Honorable High Court, we have filed the appeal before the Commissioner of the State of Nagaland. Lordship, here, the impugn order. I won't take much of your time, Lordship. Page number 52 is the impugn order.
52.
52, Your Lordship, annexure K. This honorable court directed the petitioner to file an appeal before the Commissioner, State of Nagaland, Lordship. And in compliance, the petitioner filed the appeal before the Commissioner. But however, while receiving the reply, the one cancellation order was given by the Deputy Commissioner, stating that in respect of the petitioners, respectively, Lordship.
Now, what is this cancellation order?
Lordship,
Cancellation order, page number 52.
52, annexure K, Lordship. Here,
Person to Commissioner, Nagaland. Is hereby cancelled. What was cancelled? What was cancelled?
it says pata number.
Oh, so.
Yes, Lordship, pata number.
Oh, so.
Hereby
Pata
cancelled.
number was
This
given.
order,
Earlier, pata number was given to you.
Lordship, I have applied for pata, and then the DC has given me the patas also, Lordship.
Now it is cancelled.
It's cancelled. Your Lordship, initially they were not aware. I have brought the knowledge of this honorable court that while giving the restraining as well as the eviction order, Your Lordship, the jurisdiction was not mentioned, the boundary was not mentioned in the restraining as well as in the eviction also. And they were not aware that even pata was there. So I have given annexing all the necessary documents while giving for the reply as well as during my appeal. Coming to know that there is a pata, so only after I have submitted my appeal, they came to know that there was the pata. And then, but however, Your Lordship, as per the appeal section, Section 12, Your Lordship, here. Volume 3.
Volume 3, page number?
Page number 5, page number 7, Your Lordship.
Page number 7.
Yes.
This is Nagaland eviction of persons in unauthorized occupation of public land. Yes.
Yes, Your Lordship. Your Lordship, I may be allowed to read 12(1), Lordship.
12(1).
Yes.
Yes.
An appeal shall lie from every order made by the Deputy Commissioner under subsection 1 of Section 6 or under section 7 in respect of any public land to an appellate officer who shall be the commissioner of the state of Nagaland or in any case or class of cases specified by the commissioner in this behalf, the additional commissioner of state of Nagaland. Lordship, 1A, without prejudice to the provisions of subsection 1, the commissioner of the state of Nagaland may, for reasons to be recorded by him in writing, transfer any appeal pending before him to the additional commissioner of the state of Nagaland, who shall dispose of the appeal as an appellate officer under this section. Lordship. And 12.5, Lordship. 12.5, the appellate officer may, after hearing the appeal, Your Lordship, after hearing the appeal, confirm, modify, or reverse the order appealed from. Lordship, here the impugned order was issued by the deputy commissioner. But where else? I have filed my appeal before the commissioner. So as per this eviction, as per this eviction act, Your Lordship, that the order has to be passed. First, it has to be heard. It has to be heard and has to be passed by the appellate officer, who is the commissioner or the assistant commissioner, Lordship, additional commissioner. But however, here, the order has been illegally passed.
It was not heard.
It was not heard also. Even in the eviction notice, Your Lordship, we have the petitioner I've already stated in section 6.1. Here in section 6.1, it clearly says, Lordship, page number 4, section 6.1. Page number 4, Your Lordship.
6.1.
Yes, regarding eviction order, it says, if after considering the cause, if any showing by any person in pursuance of the notice issued under section 5 and any evidence adduced, Your Lordship, in support thereof, and after making such inquiry, if any, as he may be deemed necessary, the deputy commissioner is satisfied that the public land is unauthorized occupation. Here, Lordship, before issuing the eviction notice also, the deputy commissioner has to make sure that an inquiry has to be undertaken, as well as evidence has to be adduced, Your Lordship. Only after that, the eviction notice has to be issued. But however, in this present case, what happened was, the eviction notice was not even handed over to me. It was not informed. Whereas in my application, I have given all my contact numbers also. But however, I was not informed in any manner. And then what happened? The cancellation order, the next point, Lordship, which was illegally passed by the deputy commissioner. When it has to be passed, first it has to be heard and passed by the appellate officer. That is the commissioner, Lordship. Lordship, here, I have bought this plot of land from a private individual who is the original landowner. Here it says public land. My plot of land comes within the purview of private land, Your Lordship.
It is not a public land.
It has to do with public land in this case, Your Lordship. But however, I'm saying that it is a private land. In the definition, Your Lordship, page number 2. Page number 2H. Page number 2H, Your Lordship. Public land.
Yes.
Yes, sir. Public land means any land belonging to or taken on lease by the state government, a local authority, a government company or a corporation owned or controlled by the state government, and includes any land requisition by or on behalf of the government. Your Lordship, here, this particular plot of land is not government owned. It's not been leased also. I have bought this plot of land and have been settling peacefully. While applying for Pata, Your Lordship, there is a certain procedure where no objection is issued through newspaper, Your Lordship. Notice has been issued. Your Lordship already knows on that. While issuing on that also, nobody raised objection. Nobody, till date, Your Lordship. In what manner they have issued this order is has caused irreparable damages, Your Lordship, to the petitioners. Here, even the second petitioner, Your Lordship, the second petitioner here, he is a government employee, and basing on this particular plot of land, he has applied for home loan also. And then the DC, the deputy commissioner, has issued that it is free from all encumbrance. Even the deputy commissioner has issued. So why now?
Yes.
Worship, and as such, I am praying for washing and setting aside of this cancellation order of the petitioner's land pata, eviction notice, as well as restraining order, because it is illegal, Lordship. The order has been issued illegally without following due procedure of law, Lordship, in a very high-handed manner. And Your Lordship, in the meantime, I am praying for interim also, Your Lordship,
What interim order you want?
for stay of the operation of the cancellation order as well as eviction and restraining order, Your Lordship.
Okay, for the state.
My lord, I'm appearing for respond number 1 to 5.
Yes.
My lord, at this stage, let the notice be issued. my lord.
Okay. But the learned counsel MS,
Naksumtila, Your Lordship.
appearing for the petitioner. What the learned counsel, Mr.
E. Tipapong.
Appearing for the state respondents.
Yes, my lord.
You have to file an affidavit.
Yes, my lord. I need instruction, my lord.
The learned counsel for the respondents prayed for some time to take instructions. The prayer is allowed. What about interim order?
My lord, let all the party be maintained status quo, my lord.
That will be better.
Yes, my lord.
Para, I have also heard the learned counsels of both sides in the matter of a prayer for interim order. Para, both sides are directed to maintain status quo as on today in respect of the suit land. In respect of the land, disputed land. Least after
4 weeks, my lord.
4 weeks.
Much obliged.
Item number 3.
Lordship, similar prayer, Lordship,
These are the same case.
same case. Common order has been issued.
Oh, it's the same order will do.
Same order.
Yes, Your Lordship.
Same order.
Much obliged.
Much obliged.
Lordship,
Yes.
just for coming again, this is for item number 5. There is an interim order. I pray that the interim may be.
Oh, so in item number 5, the interim order.
Item number 5.
Okay, item number 5.
For admission, item number 7.
In item number 5, we tell the who to apply. Interim order will continue. This is item number 7.
In this case, the state has already filed the affidavit. I have sought time for special occasions, Lordship. I prepared an affidavit in reply to the state's additional affidavit. I will be allowed a week's time, Lordship. A week's time to file the reply.
Here in this case, the state respondents has filed a counter affidavit. The learned counsel, Mr.
Mohan Junior, Lordship.
Appearing for the petitioner,
Petitioners.
prayed for some time to file a reply. After hearing the learned counsels of both sides, the prayer is allowed at least after 2 weeks.
Item number 11.
Yes.
Even in this case, the state has already filed the affidavit, Lordship. I may be allowed 2 weeks time to file a reply, Lordship.
Okay. Here in this case, the state respondents has filed a counter affidavit. The learned counsel, Mr. You are Mr.
Mohan Jamir, Lordship.
Appearing for the prays for some time to file a reply. The prayer is allowed after 2 weeks.
Item number 12.
Lordship.
Yes.
My lord, here I'm here to file my affidavit in reply. So allow me 2 weeks time to file my affidavit in reply, my lord.
The learned counsel, Mr. So-and-so, appearing for the petitioner praised for some time to file a reply in respect against a
Affidavit filed by the state.
affidavit filed by the state respondents. The prayer is allowed, least after 2 weeks.
Much obliged.
For orders, item number 18.
Please, your lordship.
Yes.
My lord, may I have a may I have a look at the last order,
Last order dated
4th of April.
4th of April. In compliance to Honorable Court's order dated 4/12/2022, also for the petitioner filed later of withdrawal of Wakalatnama. And permission to the petitioner. No notice returned unserved. Or notice returned unserved.
Yes, your lordship.
You are for the petitioner.
Yes, I'm for the petitioner.
And Mr. Santianger was for?
He's the leading counsel, your lordship. He's also for the petitioner.
He is also for the petitioner.
Yes, your lordship.
He has withdrawn his Wakalat number.
Yes, your lordship. The leading counsel along with his associates, your lordship, have withdrawn the Wakalat Nama, your lordship. And accordingly, we have filed an affidavit before this honorable court. And a service of notice was served to the petitioner. However, till date, it is served on, it has returned unnoticed, your lordship. Unserved, your lordship, the notice.
Fair enough. All right. Here in this case, Mr. Santianger, Sentiyanger, the learned counsel for the petitioner, had withdrawn the Wakalat number. And therefore, the office was directed to issue a notice to the petitioner. Notice was issued, but returned unserved with a comment within inverted comma, insufficient address returned to sender. Now what you will do? No, again notice will have to be sent. But the address is insufficient, says.
Your lordship, even the present counsel, we are unable to contact with the petitioner, your lordship.
Okay. The learned counsel MS. What is your name?
Vitere.
Appearing for the petitioner submits that she also could not contact the petitioner. Fair. After hearing both sides, after hearing the learned counsel and after going to the office note dated 04/04/2024, office is directed to again take fresh steps for service of notice upon the petitioner. Least after 6 weeks.
Bless you, lordship.
Orders, item number 19.
Yes.
Please, your lordship. As per this honorable court's order, 25th of March 2024, your lordship, the present council has taken steps upon the respondent number 7 by way of substituted notice, your lordship. And accordingly, you have filed an affidavit, your lordship, on 4th of March 2024, your lordship. Placing before this honorable court the service that was taken upon the respondent number 7, your lordship.
Local newspaper.
Yes, your lordship.
Heard the learned counsel MS so and so appearing for the petitioner. The petitioner has filed the necessary affidavit regarding service of notice upon the respondent number 7. Service of notice is complete upon the respondent number 7. None appears for him.
My lord, I may be given 1 week's time, your lordship, to file my reply to the counter that was filed by the state respondents, your lordship.
The respondents 1, 2, 3, 4, 5, and 6 have filed an affidavit in reply. MS so and so appearing for the petitioner prays for some time to file a reply in respect of the affidavit. The prayer is allowed least after 4 weeks.
1 week, your lordship.
After 1 week.
Oblige, your lordship.
Item number 21.
Yes. You're for a petitioner.
Yes, my lord, I am for the petitioner. I have taken step. For the district post.
Notice
From all
of the
respondents.
How many respondents are there?
There are 7 respondents. my lord.
7 respondents. Step Food Corporation of India. Who is for Food Corporation of India? You have taken steps for service of notice.
Yes, my lord.
Notice issued.
Yes, my lord. On 21 March, the Supreme Court directed the petitioner to take steps to the registered post, which I have duly complied.
And about this Central Information Commissioner, you should notice upon the Central Information respondent number 6.
Yes, I've taken
And
steps.
7?
from all the respondents.
Notices have not returned. Huh? Service report issued upon the service of notice issued upon respondents 1 to 7. What's you wait for a report. You have to wait. But the learned counsel, Mr.
And my lord,
Ipe-
I'm Patrick Sabo, and my prayer is that the name of the councils, K. Paitio and L53, their name may also be translated in the constitution.
No notices are not yet served. You have to wait. Heard the learned counsel, Mr. Appearing for the petitioner. Seen the connected office note dated 16/04/2024. Await for the service report. Least after 4 weeks.
For hearing, item number 55.
Yes, who is for the appellant? Yes.
Yes, my blessed lordship. Lordship, in this case, 2 questions of law involved. Firstly, how to determine the interest seniority between the persons holding the same post. That is the first issue to be decided. And second issue is, lordship, whether the recommendation of the Developmental Promotion Committee based on the ECR, which was never communicated to the petitioner, is sustainable in the eye of law. So that is the short issue involved in this petition.
Yes.
Also, petitioner and the private respondents are the employees under the village court organization. The petitioner entered into service as Chamadar in the year 2000. Whereas the private respondents entered in the year 2001.
Yes.
Therefore, in the entry point, the petitioner is senior to private respondent by 1 year.
By 1 year.
Yes. Subsequently, promotion were given lordship to the rank of superior. Thereafter, by command order, which was issued on 24/10/2016, both the private respondent and the petitioners were promoted to the rank of Subedar Major. Therefore, Lordship, as per the principle of law laid on, the seniority between the petitioner and the primary respondent and the rank of Subedar Major has to be determined from the date of recommendation of the DBC. Both of them were recommended on the same day, promoted by command order dated 24 then 2016. Therefore, Lordship, what should be the criteria for determination when the two persons are promoted by the same order? The law is the entry point, Lordship. The entry point has to be determining criteria for determination of the interest seniority between the person who were promoted the same day. However, Lordship, by the imbued seniority list, primary respondents were given seniority over the petitioner on the ground that the primary respondent joined 1 day ahead of the petitioner in the promoted post.
Yes.
However, Lordship, the principal law is very clear that such seniority, interest seniority should be determined on the basis of the date of entry in government service.
Yes.
Which was not taken into consideration by the authorities. That is the first issue to be decided. Now, the second issue, Lordship, based on the impugned seniority list, wherein the private respondent has been shown senior private respondent, the DBC considered that seniority list and recommended the private respondent for promotion to the post of assistant director. Not only the seniority list was considered, Lordship, the DBC also considered the ACR of the petitioner as well as the private respondent. However, Lordship, the ACR placed before the DBC by the department, it appears that in my ACR, nothing has been mentioned, no remarks at all. Like ACR has been submitted to the DBC, and the DBC has considered the like ACRs. Lordship knows the law is very clear. Every entry in the ACR, whether it is called excellent, the record that should be communicated to the employees. And promotion without communication of such ACR, entry in the ACR, is illegal. Therefore, Lordship, first ground, the determination of seniority and issuing of the impugned seniority list is totally illegal. Number one, because the petitioner is senior. Secondly, the recommendation of the DBC based on this impugned seniority list and uncommunicated ACR, remarks of the ACR, is against the law laid down by the Honorable Supreme Court. So, Lordship, therefore, Lordship, I take your Lordship to the elections in my writ petition, Lordship.
Yes. He was appointed on 25th July 2000.
Yes. This is my initial appointment order.
Yes.
And page 28 is my promotion to the boss of Subedar.
On 10 February 2006.
Yes.
On what post he was appointed?
Respondent, Lordship.
As Zamadar.
The petitioner?
A petitioner?
Yes, Lordship, as Zamadar.
As Zamadar.
Thereafter, promotion to the boss of Subedar by annexure P, page 28. And next page, page 29, Lordship. This is a common promotion order of the petitioner and the private respondent. This is promotion to the post of Subedar Major. Serial number 1 is the brevet respondent, Lordship. Serial number 2
Is the petitioner.
Lordship, may kindly by the same order, same date, Lordship, you were promoted. Page 31. Lordship. Page 31, Annexure D.
Yes.
This is the tentative seniority list issued after promotion to the post of superior major. Next page. This is tentative seniority list memorandum dated 14 September 2008. 14 September 2008.
Yes.
Page 33, Lordship.
Yes.
Serial number 7.
Petitioner's name is in 7.
Serial number 7. The third column, Lordship. Date of joining into government service. Third column on the right hand side. 27/7/2000. That's your Lordship, got it?
Date of promotion. Third column, 1, 2, 3. Date of last promotion.
Date of last promotion is 24/10/2016.
Yes.
That is, I refer to your Lordship, the promotion of 24/10. And serial number 8, Lordship.
Yes.
This is brevet respondent. Date of joining in the government service, 2001. There's no dispute, Lordship. I entered into government service in the year 2000, whereas the brevet respondent entered into service in 2001. Date of last promotion is also on the same date, Lordship.
Yes.
So this tentative seniority list was prepared in accordance with the data of entry and in terms of the data promotion to the boss of Soviet Union. However, Lordship, we kindly turn to page 41. This tentative seniority list was never published, Lordship. This seniority list was never brought to the notice of the petitioner. The petitioner was not aware of publishing this seniority list. All along this seniority list was kept undisclosed, Lordship. This is stated, Lordship, subject, merit, Lordship. This is also tentative, Lordship. Tentative seniority list of all the superior major under the organization was on 15/9/2015. In continuation of this office memorandum of item number dated 14/9/2018, which I've referred, the tentative seniority list.
Yes.
Final common seniority list, here the word final has been used, Lordship. Although it is subject, it is tentative. Of superior major of all district under village park organization is prepared enclosed as Annexure 1. Page 42. Now, in the earlier seniority list, I was at serial number 7, Lordship. Now the position has been reversed, Lordship. Serial number 7 is
You have gone to 8.
8. Date of entry, same, Lordship. Date of entry in the government service, same. On the 5th column, Lordship, date of last promotion and date of joining. Lordship, we can see. Serial number 7, date of last promotion and date of joining. 25/10/2016. Serial number 8 is the petitioner, Lordship.
And yours is 26/10/2000. One day later.
This date, Lordship, is the date of submitting the joining report and the promoted post. Therefore, this seniority list was prepared in terms of the date of joining and the promoted post. So my question is, Lordship, whether date of joining is the criteria for determination of industry seniority or the date of entry, or for that matter, date of promotion. Law is very clear, it should be from the date of entry, or it should be from the date of the recommendation of the TBC. Date of joining and the promoted post is irrelevant so far as the determination of the tentative industry seniority list is concerned. The government, as well as the private respondent by filing affidavit in opposition, have taken this stand that this seniority list was prepared in terms of in the promoted post. Therefore, Lordship, the question for the determination of industry seniority list is whether the date of entry into service should be considered for determination of seniority or the date of joining in the promoted post. So before coming to the imbued promotion recommendation of DBC in the promotion order, I'd like to refer to some judgment with regard to the determination of seniority. Thereafter, I'll come to the second imbued order. I've got a list of books, Lordship. 1993, Supply 2 ECC.
Yes.
Facts, Lordship, facts may be different, but we are allowed to read facts, Lordship. There are 2, 3, 4, and 5. There are 2, Lordship. All the above bills are disposed of the common order as a difficult question of law are both in this cases. For the purpose of understanding the controversy risk in all the cases, we are stating the facts of the bill arising of the special deputation. The appellants and the private respondents were sub-engineers in public health engineering department of government of Madhya Pradesh. They are governed by the Madhya Pradesh Public Health Engineering Gazette Service 9. Under Schedule 4 of the roles, the next higher was for promotion from the post of sub-engineers in civil or mechanical is to the post of assistant engineer. The minimum wage for sub-engineer to qualify for promotion to the post of assistant engineer is 12 years for diploma holders and 8 years for sub-engineer who obtain degree of graduation in course of service. Earlier, 60% quota for the post of assistant engineers was fixed by direct recruitment and 40% by promotion from sub-engineers, draftsmen and head draftsmen. By an executive order dated 1979, February 7, 1989, quota of direct recruitment was reduced to 50%, and the quota by promotion increased to 50%. This 50% quota promotion with which we are concerned, and the above case has been subdivided into following. Lordship, paragraph 3. Paragraph 4. The state government has been applying the principle of counting seniority of graduate sub-engineer from the date of their continuous officiating, irrespective of the date on which such diploma holder sub-engineer acquired degree of graduation and engineering. On this basis, the Departmental Promotion Committee took into consideration 30 graduate sub-engineers for promotion to the post of assistant engineers. The DBC, by order dated December 4th, 1989, Bevered a panel of 18 graduate sub-engineer found suitable for promotion to the post of assistant engineer. The government, by order dated 6 December 1989, promoted M. B. Joshi and 6 others as assistant engineer who are appellant and a bill arising out of special lab petition number so. The private respondents in this appeal filed application number so in Madhya Pradesh Administrative Tribunal, Jabalpur, challenging the aforesaid orders dated 4 December 1989 and 6 December 1989. The contention of this presence before the tribunal was that seniority for the, this is important, Roshi, seniority for the purpose of promotion to the post of assistant engineer and 10% quota of graduate sub-engineer, completing 8 years of service ought to have been considered from the date of attaining the graduate degree of engineering and not from the date of appointment as sub-engineer. So that was the issue before the tribunal. The tribunal placed reliance on its earlier decision that is so and so, so and so, and so and so, held that the seniority of diploma holder sub-engineers equating the degree of graduation in engineering for inclusion and tradition list of sub-engineers should be counted from the date of acquisition of graduation in engineering or of any other equivalent degree and not from the date of their initial entry as sub-engineer. That was the decision by the tribunal. Applying the opposite principle laid down in Su case, the tribunal held that the applicant whoever respondent in the appeal, having secured the degree in engineering bureau to respond number 3 to 9, the appellant and the appeal will rank higher in the gradation list of sub-engineers. The tribunals as such allowed the petition filed by them and directed district government and the engineering chief public health engineering department to convene a special WC to consider the applicants for promotion to the post of assistant engineer as of 4 December 1989, and if found suitable for promotion, promote them and give them seniority over respondent number 3 to 9 within 4 months from the date of receipt of the order. Paragraph 5, Worship. The short controversy arising in this case relates to the determination of seniority among the diploma holders, sub-engineers who acquired the degree of graduation in engineering during the periods of service, qualifying them for promotion in 8 years to the post of assistant engineer. It is admitted position that there is no specific role governing such situation. Relevance extra constitutional for the roles of place in the Madhya Pradesh case is not relevant. Worship, kindly come to paragraph 14.
14.
Yes.
Yes.
This is the finding and principle laid down by the big scholars. Paragraph 14, may I read, Worship?
Yes.
It is further important to note that in the cases before us, the government itself has been adopting the practice and making promotion as conducted by the appellant, and we are upholding such practice. And so in this case, also this court has appealed the practice followed by the government. It is also well settled principle of service jurisprudence that in absence of any specific role, the seniority amongst person holding similar posts and the similar cadre has to be determined on the basis of the length of service and not on any other fortuitous circumstances. Same thing, Lordship.
Yes.
I was appointed in the year 2000. A respondent appointed in the year 2001. Therefore, as per the principle laid down by the apex court, seniority in the senior has to be determined on the basis of the length of service. Paragraph 16. In these circumstances mentioned above, we are clearly of the view that the tribunal was wrong in determining the seniority from the date of acquiring degree of engineering, and it ought to have been determined on the basis of the length of service on the boards of sub-engineer, and the state government was right in doing so. There was no infirmity and order passed by the government. In the result, we allowed the appeals. Principle is very clear. Worship, second authority is 2011 at SCC. (115).
Yes.
Paragraph 10, Lordship.
Para?
Paragraph 10.
Paragraph
Notice of
10.
facts. Paragraph 10, 10.
10, yes.
Page 118. By judgment and order dated 26/7/2000, the tribunal dismissed OA number so of 1995 and in Bara so held as under. It is fact that the date of recommendation of the applicant who belongs to surgery discipline and the private respondents belonging to medicine discipline was same. That is on 14/4/1983. Also that the rules provide for fixing the seniority based on the date of recommendation of the UBC maintaining entry seniority as per the recommendation. It is also a fact that the respondent did not approach UBC for preparation of combined merit list and of such specialized, which he should have done as per UOBT's instruction for same future promotion prospect for this specialized, and also the fact that the separate seniority list for number of specialized disciplines and separate promotion prospect thereof were not visible. From the extract of note sheet filed by the respondent, it is seen that the commission, based on the detailed examination, decided to fix the seniority in such case, based on the date of interview, that is the candidate interviewed, on an early date to be senior to those interviewed on a later date. Indeed, condition of the learned counsel for the applicant that their seniority should have been fixed based on the date of birth cannot be accepted since presumption. Since presuming this criteria was to be adopted, then the very purpose of recording the seniority based on age may be relevant in case of regretment, where no merit list is met and the case along, or where the recommendation are only as fit or unfit. Worship paragraph 11. Being agreed, the applicant filed a writ petition before the High Court of Madhya Pradesh. By immune judgment dated 36/2003, the High Court dismissed the writ petition affirming the methodology adopted by UBC for fixing the seniority of two different disciplines. Both recommendations were back at the same time. The High Court in Para 15 held that. Para 15 also. What is reasonable to be seen in the obtaining factual metrics is that under critical circumstances, the agency merit list was not relevant as the position for factual subsidiary. All the UBC have evolved best which indicates that date of interview or criteria for fixing seniority. In such a case, ordinarily this will not quite regular, but that is to be borne in mind that regular circumstances are solved by taking recourse to innovative methods. The tribunal in Para 6.1 has reproduced the date of advertisement and the date of recommendation letter of UBC. We have also reduced the same above. The date of advertisement for the boss of specialized surgery was on 13/11/1982. The date of advertisement for the boss of specialized medicine was 6/11/1983. Evidently, there was advertisement for the boss of specialist surgery earlier than the specialist medicine, but the interview of the specialist medicine was on 15/3/1983. 16/3/1983, whereas the date of interview of specialist surgery was 1983 and 24/3/1983. The tribunal has taken note of the fact that from the note sheet which has been produced by UBEC, it was perceivable that recommendations were made on the date of interview. Thus, selection was made on that date. It is noticeable that the recommendations were sent on the same date, that is 14/4/1983. Thus, the date of interview has earned the status of date of selection. Submission of Mr. Gupta is that it can be fortuitous circumstances as the interview in one subject may take place earlier than the other. The offered submission may appear on the first blush to be quite attractive, but on a closer scrutiny of the same it is to be revealed. The UBC has determined the seniority on the basis of the date of interview. and the date when selection had taken place. In absence of any document on record, in the absence of any preparation of merit list, and the absence of drawing of the seniority list at the initial stage, and taking note of the regular facts and circumstances of the case, we are after consider view the UBC has adopted a rational approach and tribunal has not.
Okay, is there any
not
ru- is there any rules for promotion?
No.
There is no rules for
No.
promotion. The principle has been laid down in para 18.
Yes, Lordship, I'm coming to that. And paragraph 18, Lordship. Paragraph 18 and 19. Hear it, Lordship. The law is clear the seniority is an incidence of service, and where the service rules prescribe the method of its computation, it is squarely governed by such rules. In absence of provisions, ordinarily length of service is taken into account. It is directly. This judgment also, the same principle has been reiterated. And next, Lordship. 1998 supply ICC 2.
Yes.
I'll just read two paragraphs, Lordship. Paragraph 4 and 5. There is no dispute, paragraph 4, Lordship.
You were reading the 1988 supply?
220, Lordship.
220? 224.
220.
Or 220.
Here, brush up in others.
Oh, but there are only 3 paragraphs here.
Yes, Lordship.
You are reading from which?
I'm reading the paragraph 4.
Paragraph?
Paragraph 4.
Paragraph 4.
4.
But there are only 3 paragraphs here.
No, Lordship.
This is 1988 supply Supreme Court cases 220. Only 3.
The name of the party is K.R. Prasad in others.
K.R.
No, Lordship. I'm sorry, Lordship. 221, Lordship.
221, next one.
Next page.
Desula.
Yes.
Rama. Yes.
I'm sorry, Lordship. Paragraph 4. Page 224.
Yes.
There is no dispute that both Tariq recruited engineers, assistant engineers, and also promoted assistant engineers are entitled for promotion as executive engineers. The role requires Tariq recruited to have more than 6 years of service. Well, for promotion, the prescription, for promotees, the prescription is 5 years of service for being eligible to be considered for promotion. As in many other service roles, there is no provision in the rules under consideration that Tariq recruits should have preference over the promotees for promotion for the purpose of industry seniority. In absence of such a role, the High Court followed the guidelines indicated in the general rules, which provides that seniority shall be determined by the date of first appointment to the service. The High Court found that the respondent number 3 and 4 came to service as assistant engineer long before the appellant were recruited as assistant engineer. In fact, in paragraph 6 of this judgment, the learned single judge in the second writ petition is indicated that the respondent number 3 and 4 were temporarily appointed as assistant engineer on 14 August 1959 and 19 May 1960 respectively. And exercise a board under so roles that is not relevant, Lordship. Paragraph 5. Paragraph 5.
The only dispute is that you joined in the year 2000 and the private respondent joined in the year 2001.
Yes,
Even then, he was given seniority.
yes, Lordship.
That is the case.
Yes.
So, what do you want state respondent for?
No, Lordship.
You have not
Regarding the
completed.
second MBNO draft, I'm yet to
Yes.
submit.
Hmm.
I have another authority, Lordship.
Hmm.
These judgments from this what Lordship, 2002, 3 GLD 504.
Two thousand two 3 GFD 504. Yes.
It's a short judgment, Lordship. Both paragraphs only. I'll start from paragraph 1, Lordship. The petitioner challenged the seniority list issued by the memorandum dated 12 January 1983, by which the seniority position of junior amends in the Directorates of Land Resources and Settlement. Government of Tripura has been finalized and subsequently issued a memorandum bearing number so dated 9 April 1981, by which the final seniority list for the post of so under DL Iris Government of Tripura had been published. Paragraph 2. The petitioner, along with others, were temporarily appointed to the post of junior amend, right? Memorandum dated 5/1/1979. Subsequently, the petitioner and other junior amend had been redesignated as amends with effect from 1 to 1983, pursuant to memo dated 16/6/1983. The petitioner, along with other amends and junior amends, had been divided to undergo training at training center at so in the year 1979 to 1980. And amongst the 34 trainees, the petitioner secured higher marks. And in the result sheet, his name paper is 1. That training, but while publishing the seniority list at 12/1/1983, the petitioner name was figured much below his colleagues, whose performance and the training had admittedly been inferior to petitioner, but in the subsequent seniority list, the seniority of the incumbent holding the post of junior enemies had been determined according to the position secured in terminal training. And as such, the petitioner sought for it. Particularly, directing requesting of application to seniority list and also agree the mandamus directing to respond to the facts to seniority. And the petitioner decides the respondents according to the merit position available in the result sheet of the FOC training. Paragraph 7, Lordship. In the service jurisprudence, seniority cannot be met even upon the result of any service training exit. Conducted after the appointment of an incumbent. The seniority is to be determined to the date of appointment itself, and any event having subsequent to the date of appointment cannot be a criterion. So that is the principle that I'm not reading the remaining paragraphs. Therefore, Lordship,
Yes.
Therefore, Lordship, on the issue of industry seniority, or the determination of industry seniority between the petitioner and respondent, the law is very clear. It should be from the date of entry into service. And when the respondent dispute project the petitioner and the service wasn't. Whereas the respondent enter into the service year 2001. Therefore, Lordship, the petitioner is senior to the private respondent. However, by the imbued tentative seniority list, Lordship, the date of joining in the promoted post has been taken into consideration for determination of seniority, which is contrary to the law laid out by the Honorable Secretary. Therefore, the imbued tentative seniority list issued in the year 2018 and is sustained in the law. By filing the affidavit in opposition, have enclosed the joining report submitted by the petitioner as well as the primary respondent. There is no dispute, Lordship. Lordship, interestingly, the promotion order was issued on 24/10/2016. Promotion to the post of Suriname Major. 24/10/2016.
24, 25.
24. Promotion. Page 29. The petitioner, Lordship, this promotion order was issued on page 29. As Lordship, this is stated 24/9/2016. This order was issued from the office of the Commissioner Nakaling Kohima. The petitioner, Lordship, the petitioner is posted at Twinsang headquarters, and the private respondent was posted at Kifari during that period of time. Therefore, Lordship, the petitioner received this promotion order only on 26, Lordship. Therefore, right after he received the promotion order, that is 24/10/2016, he submitted the joining report on 26. However, it appears that the primary respondent received this promotion order on 25th. Therefore, he submitted his joining report on 25th, Lordship. Therefore, whether the date of submission of the joining report has to be taken into consideration for determining of interest seniority list. No, Lordship. It should be from the date of appointment, as per the principle laid down by the Honorable Supreme Court.
Yes.
Therefore, Lordship, the determination of seniority based on the date of submission of joining report is totally illegal, and therefore the imputed seniority list, which was issued in the year 2018, is liable to be citizen. Now, my second point, Lordship. Lordship, by the respondent, by filing affidavit of no, it is not only the seniority, but the DBC have considered the service reports of the persons who are on the zone for promotion. First, me kindly turn to this. This is the recommendation of the government. Here it, Lordship. Page 40. This document was obtained through the RDI, Lordship. A meeting of Government Promotion Committee to consider the case of regular promotion of officers on the home development, BGO, was held on 15/7/2021 in the conference hall Nakaling office. The following members are present. Next, Lordship. The members. The Departmental Promotion Committee, after going through the senior list, number one is senior list. Apparatus and service reports as available, recommended as shown below. The Departmental Promotion Committee have considered the seniority list first. Apparatus and service reports. Serial number 4 is the private respondent.
He is the private respondent.
He was recommended. However, Lordship, the petitioner promotion was denied. How the upper was considered, Lordship, we kindly turn to the affidavits filed by the private respondent. Page 30, affidavit in opposition filed by respondent number 7. Page 30. 30.
Yes.
Near Lordship.
30. Yes.
This is letter dated 16 April 2021. Do the Secretary Nagaland Public Service Commission.
No, page number
30. Affidavit filed by respondent number 7.
Just a minute. Where is the affidavit? Oh, this is the affidavit. Page number
30.
Oh, yes. To the secretary.
Yes. To the Secretary so Lordship. This letter dated 16 April 2021. Proposal for promotion to the post of assistant commandant under village card organization. On continuation of this development, proposal number so I'm going to what you will request you for promotion. Duly fill out in for promotion. So vacant post of assistant commandant DG, Nagaland, under Nagaland village card organization. Documents for say the enclosures. Number 2, seniority list. Enclosures is in the letter. Includes with same letter. Page 30.
Page 30, yes.
Seniority list was enclosed. Serial number 5 is upper was enclosed. Serial number 9, crop service role enclosed. So, Lordship, may kindly come to page 30. Page 34.
Yes.
No, Lordship, page 35. This
Yes.
This is the documents placed before the DPC by the government for consideration of promotion. Serial number 1, first column, serial number 1 is
the private respondent.
First, we kindly see the upper remarks. Very good, very good, very good. All are very controversial. Serial number 2 is CD Wingdown Gongyak Sub-Major, Subida Major. 2016 to 2017, no remarks. Next column, no remarks, nothing, blank. This was placed before the DBC, as per the reports available here also. And the DBC considered this blank remarks. I'm making a submission based on the documents enclosed by the respondents lordship. Therefore, lordship, such type of exercise made by the government and accepted by the DBC for submission of blank remarks, whether such exercise is permissible. And lordship, law is very clear. Every entry in the ACR remarks should be communicated to the employee concerned. This remarks was never communicated to the petitioner. Therefore, the action of the government as well as the DBC is head by the principle laid out and dip that case. By writ petition. Based on the recommendation of the DBC lordship, page 35, my writ petition lordship, is also the imperial. This is notification dated 19 July 2021. On the recommendation of the Durable Promotion Committee of Government of Nepal is pleased to bring the following Sabida Major to the vacant boss of assessment government as mentioned against H under Nepal Village Card Organization. So, I'm challenging this notification in respect of serial number 3, private school number 7.
But in this list, your name is not here.
No, Lordship. This is the bill promotion order of Rabbi respondent to the boss of assistant government. This promotion was made based on the review seniority list and on the strength of the recommendation of the DBC, which I referred to, Lordship. So far as the issue of determination of industry seniority is concerned, Lordship, I place the judgment entered by the Supreme Court. And on the issue of non-communication of the reports of the PCR, and this judgment. 2008 ACC 725.
Yes.
That is the facts also. The departmental promotion where also.
You are reading from where?
Paragraph 4.
Para?
Paragraph 4.
Para. Yes.
The Departmental Promotion Committee held in its meeting on 16/12/1994. In that meeting, the appellant was not held to be eligible for promotion, but his juniors were selected and promoted to rank up superintending engineer. Hence, the appellant filed a writ petition before the Gauhati High Court, which was dismissed, and this appeal before the appeal bench also fell. Aggrieved, this appeal has been filed by special left before this court. Paragraph 10, Lordship. Paragraph 10. This is the principle laid down. That it's not Lordship.
Paragraph 10.
Yes.
Yes.
Hence, in our opinion, the court entry should have been communicated to us to enable him to make the decision. Praying that the said entry for the year 19 should be updated from court to the. Of course, after considering such a deviation, it was open to the authority concerned to check the resolution and confirm the court entry. Oh, of course, in a plain manner. But this an opportunity of making such a resolution should have been given to the evidence. In fact, it only have to be have been visible that the evidence have been communicated the court entry, which was not done in this case. Hence, we are of the opinion that non-communication of court entry was arbitrary and hence illegal, and the decision relied upon by the land council in this one. Para 16. In our opinion, if the office memorandum that is used is interpreted to mean that only adverse entries or entry need to be communicated, not to it would become arbitrary and hence illegal. Since it may be adversely affect the government's chances of promotion or to get some other benefits. For example, if the benchmark is that an government must have record increase in the last 5 years, a court entry for only 1 year will get this court entry will be due to personal big office severe or because of severe asked him to do something wrong which the incumbent refused, or because the incumbent refused to do psychopathy of his severe, or because of communal prejudice, or do for some other extremist consideration. Paragraph 17. And or when re-entry at the ECR of public servant must be communicated to him within a reasonable period. Whether it is more fair, average court, or very court entry. This is because non-communication of such an entry will restrict effect and produce influence. Thus, non-worship. Had the entry been communicated to him, he would know about the assessment officer and conduct by his survey, which would enable him to improve his work in the future. Number two, he would have an opportunity of making representation against the entry if he feels it is raised below 3 weeks.
Yes, you continue.
And brief for its application. Hence, non-communication of any entry is arbitrary, and it has been held by the Constitution Bench decision of this court that arbitrariness values Article 14 of the Constitution of India.
Yes.
This was paragraph 18. 1/8.
Yeah.
Paragraph 18.
15.
Yes, 1/8.
Hmm.
Thus, it is not only when there is
No, para
1/8.
1/8. Oh, yes. Yes.
Thus, it is not only when there is a benchmark, but in all cases that an entry, whether it is for fair, average, or very good, must be communicated to a public servant. Otherwise, there is violation of principle of fairness, which is the soul of natural justice. Even an outstanding entry should be communicated since that would boost the morale of the employees and make him work harder. Para 22. It may be mentioned that the communication of entries and giving opportunity to represent against them is particularly important on higher posts which are in paramedical structure, where often the principle of elimination is followed in selection for promotion. An event in a single entry can destroy the career of an officer, which has otherwise been outstanding throughout. This often results in grief, injustice, and heartburning, and may shatter the morale of many good officers who are subversive due to this arbitrariness, while officers of inferior merit may be promoted. Para 23. In the present case, the action of the respondent in not communicating the court entry for the year 1993 to 1994 to the appellant is an arbitrary and violative of natural justice because substance the court entry operates as an adverse entry for the reason given above. Therefore, as per the principle laid down in this dictat case, whether it is called fair, excellent, very good, or bad, for that matter, all the entries should be communicated before consideration of the promotion. However, Lordship, the benchmark in by ECR was never communicated to the petitioner. That uncommunicated remarks has been considered by the TBC, which is in total violation of the principle laid on by the ethics. Therefore, Lordship, the recommendation of the TBC recommending the case of the previous for promotion and the immune promotion order cannot sustain thereafter. And Lordship, the state, by filing affidavit, it includes a draft service law. According to them, the provision of the draft service law has been filed. Yes, Lordship, there's decisions that if there is any intention to follow the provision of the draft service law, that can be followed. There's no bar. So, Lordship, we kindly come to government affidavit. The government includes a draft service law. Page 24. Nothing has been mentioned in this draft service law as regards the determination of industry seniority.
Page 24.
Yes. That's your worship, Pati. This is the government of Nagaland village part organization draft service law. There is no provisions, nothing has been mentioned in this rule about the determination of industry seniority. However, Lordship, we kindly come to rule page 27, rule 7.
Yes.
The Governmental Promotion Committee.
Page
Yes.
Yes.
Rule 7. Governmental Promotion Committee. Worship, may kindly come to Roman 3. The same page. Same page, page 27.
27.
Page 27
Of the
Draft service role.
of their affidavit.
Yes. Worship.
Page 27 is something different.
Permanent affidavit, Worship.
Affidavit is part of their
Page 24 is the draft service role.
Page 24.
Yes.
24 is the what the list schedule.
Respondent number 1, 2, 3, 4, and 5, 6. Affidavit filed by respondent number 1, 2, 3, 4, and 5, 6.
Oh, this is 7. 1, 2, 3, 4, 5, 6. Page number 25.
24.
24.
This is the
This
draft.
is the government
Yes.
of Nagaland Village Guards Organization.
Village Guard Gazetted Service Roll 2014.
Hmm.
This is not published, Lordship. This is an on draft stage, Lordship. Page 27. Come to page 27.
Yes.
Governmental Promotion Committee.
Yes.
Roman 3, Lordship.
Ah, yes. The selection shall be.
Yes, the selection shall be based on seniority, Lordship. Seniority. With due regard to the merit and suitability. The number of vacancies and the grade to which promotion are to be considered shall be determined, and the head of the government shall furnish the following particulars together with the comments, if any, to the government and performa as prescribed by the Public Service Commission for the purpose. The number of officers to be considered for promotion from the final seniority list in order of seniority shall be thrice the number of expected vacancies, and the list should contain the following. User of the person concerned, ACR award for the last 5 years, duly reviewed and accepted by the concerned. Lordship, I've already referred to your Lordship the ambient tentative seniority list. That tentative seniority list was placed before the division, not a final seniority list. What the rule says, it should be final. It should be final seniority list. Because, Lordship, the government have taken a stand that it's not only the seniority as per the service role, seniority as well as the service role has been considered. That is their only statement. That is why I'm submitting, Lordship. As per the role, it should be the final seniority list. Not indicative. And secondly, Lordship, ACR above for last 5 years. Your Lordship has already sent my ACR, which was blessed before the DVC Lordship. Blank ACR. The DVC is considered my blank ACR, and the tentative seniority list as final seniority list. Otherwise, DVC would have rejected the seniority list, which was not final, which was not published. But that was considered by the DVC in violation of Rule 7, provisions of Rule 7 of the rules. Direction is violation of the own rules, Lordship. Therefore, Lordship, the entire action from the date of publishing the tentative seniority list, determination of seniority, placing the documents before the TBC, recommendation of the TBC, are illegal, Lordship. And as per the direction of this honorable court, the state respondent filed an petition of affidavit. Which may kindly My ACR, blank ACR was placed before that. However, as per my ACR, there were entries in my ACR which was never put up, placed before the ACR. So they are contradicting themselves. Worship, can you turn to ACR? Additional affidavit. Affidavit filed by the state respondents. Compliance affidavit.
Affidavit level by respondents 1 to 6.
Yes, Worship. Paragraph 2, Worship.
Yeah.
Paragraph 2.
Oh, page number?
Page 2.
Page 2.
Only 3 pages.
Oh.
All right, I'll read the entire records, Worship.
Hmm.
Not by order dated 12/12/2023, the Honorable Board has directed the respondent to file an affidavit stating what were the grades given to the petitioner for 5 years. That is from 2017 to 2020 to 21. Compliance of the Honorable Court order, herein that my remarks has been given here. This is the extract of the ACR. Page 4. Page 4. This is a matter address. My learned friend, Government Advocate. By which the greetings benchmark has been forwarded by the state authorities. Lordship, page 5. Last page. This is the remarks. Additional compliance affidavit, Lordship. Page 5.
Page 5 of what?
Page 5 of the compliance affidavit. The affidavit which
Six, 7.
compliance affidavit filed by
Affidavit in reply.
no. Was already affidavit.
Your affidavit in reply.
No, compliance affidavit.
This one.
Compliance affidavit.
Oh, yes.
Compliance affidavit filed on behalf of the respondents.
These remarks are your remarks.
Yes.
Petitioner's remarks.
My remarks.
Paragraph 2.
Paragraph 2. This is the remarks. Extract of my ACR.
These remarks were communicated to you or not? Those are communicated or not?
No, Lordship.
Not at all.
No, not communicated. And finally, page 4. It's
Yes.
the letter.
Yes.
Forwarding the remarks, page 5. The remarks of page 5.
These are for which year?
It is mentioned in the chart, Lordship. Page 5.
Yes, sir.
2016 to 2021. This is by Deputy Commandant Bechi Montesa. Lordship has sent various remarks in my ACRs. Various readings in my ACRs.
Yes.
However, Lordship, the documents which was placed before the DBC my remarks are kept blank, which
During the period 2021, there is no remark.
no remark. Lordship, my submission is, Lordship, here the authorities have given the remarks in my issue. However, in the documents which was placed before the TBC, there is no remarks at all. Your Lordship has already said the blank remarks. So they are contradicting themselves. And this remarks was never placed before the TBC. My remarks. Only blank remarks was placed. Therefore, Lordship, the action of the authorities is totally illegal and arbitrary. Wherein reference of this honorable court is called for.
Yes.
My last, I'm not referring to the affidavit filed by respondent. Respondent number 7 also filed affidavit, taking the same stand of the government, Lordship. However, Lordship, respondent number 7 raised objection on the ground that there is delay in approaching this court, for which the writ petition deserve to be dismissed or delay in lectures. Lordship, writ petition was filed. It's very important, Lordship. I filed my writ petition on 10/11/23, challenging the immune recommendations of the TBC dated 15/7/2021 and the immune promotion order dated 19/7/2021. I approached this court after lapse of 1 year. Because I filed a petition and then 11. Why I approach only on 10/11/2022?
Paragraph 7
of my petition.
Yes, yes.
May I read, Lordship?
Yes.
That by the official memorandum, objection, correction, reflection, if any has been invited to be submitted within 30 days from the date of issue of the memorandum to the seniority position reflected. No complaint to the seniority list was submitted by the officers in as such. Inasmuch as if there is any complaint, further notice to the affected person should have to serve. It is stated herein that apart from the said tentative seniority list, the petitioner can accuse any other official seniority list such with a mutual paragraph 9, Lordship. Paragraph 9. That While the petitioner was expecting his promotion to the next higher post of assistant commandant, in the month of February 2022, this is my statement, in the month of February 2022, the petitioner came across the imperial order dated 19 July 2021, whereby the respondent number 7, who is junior to the petitioner, has been given promotion to the post of assistant commandant. The said promotion was said to have been given under the condition of the developmental promotion. The name of the respondent number 7 is reflected as number 3 of the said promotion. Now the petitioner is posted at Mall Street, and the respondents was posted at Kefari. As such, the petitioner was not aware about the issue of the said notification. That is the emblem of the Rashid. However, on coming to know about the promotion of respondent number 7, who is junior to the petitioner, the petitioner rushed to Kohima and advised the authorities about the illegal and predatory action and promoting the junior officers and requested to rectify and cancel the report the promotion of respondent number 7. The authorities assured the petitioner that his previous would be looked into. However, despite lapse of time, there has been no positive action forthcoming. As such, the petitioner submitted a representation dated 12/9/22 to respondent number 7, highlighting his grievances and requested to revoke and cancel the promotion of respondent number 7. That the petitioner begged to state that since the petitioner was in dark, the basis of recommendation of the promotion committee for promotion of respondent number 7 without considering the petitioner, who is senior to respondent number 7, information under RDI has been sought from the authorities on 12/9/22 through one suicide. Pursuant to the RDI application, respondent authorities white letter dated 3rd October 2022 furnished the minutes of the meeting of the Governmental Promotion Committee held on 15/7/2021. That was furnished only in the month of October. It is certain from the said minutes of the Government Promotion Committee that the recommendation was made based on the seniority list, ABAR, and service records of the Sweden. Paragraph 12. That the petitioner begged to state that after receiving of the minutes of the Governmental Promotion Committee through the RDI, the petitioner on inquiry from the government was surprised to discover a seniority list subject major allegedly issued white memorandum dated 13 November 2018. This seniority list worship was kept undisclosed. Only after I come to know about the promotion of the previous one, and after getting the necessary information from the RTI, I discovered this only in the year 2022. And this is seniority list. The name of the respondent number 7 is reflected as number 7, showing the date of last promotion and the date of training to the post of Secretary Major as 25/10/2016. Whereas the name of the petitioner has been shown below, respondent number 7 is shown number 8, and the date of promotion and the date of training is shown as 26/10/2016. Although they were promoted by command order dated 24/10/2016, the petitioner has been informed that the said seniority list was placed before the Governmental Promotion Committee, and accordingly, the recommendation was made on the seniority list. Last paragraph.
Page number?
Page 19, paragraph 17. Page 19.
Yes.
That the petitioner begged to state that the imperial memorandum dated 30/11/2018 was never served to the petitioner, and the petitioner discovered the said memorandum dated 30/11/2018 for the first time only in the last week of October 2022. As such, the petitioner had no opportunity to raise an objection, as he was in doubt about the seniority position reflected in the uncirculated seniority list. Therefore, such action of the authorities is liable to be interfered with. by setting aside and quashing the Indian memorandum dated 30/11. That is the 30/11 memorandum of 30/11 and 18 is the Indian deleted scenario discussion. Therefore, Lordship,
Yes, sir.
my last submission, Lordship. There is no deliberate delay in approaching this court. The petitioner is challenging the deleted seniority list of during appeal because that deleted seniority list was undisclosed, which came to the knowledge of the petitioner only in the year. And so far as the ambient promotion of the previous one, which was made in the year 2020 is concerned, I've explained in my petition, which I've just read out the paragraphs, Lordship. Therefore, there is no deliberate delay. The proper respondent have his objection with regard to delay in approaching this court on one ground. By the same imperial order of 2021, whereby the respondent number 7 was given permission, the officer posted at Mount headquarters were also given permission. Therefore, the petitioner who is posted at Mount should have known about the promotion of the collects. Which may kindly consider one aspect of the matter. This village court organization is set up for policing of interior border areas under 5 districts, underdeveloped district. The citizens residing under these 5 districts are considered as backward tribes in the state of Nagaland. The government of Nagaland also provides special reservation for employment also because of their social and economic status. The petitioner hails from that area, Lordship. And although he was appointed on the home guard, village guard organization and posted at Mount Lordship, that is the important. From the date of appointment in the year 2000, Lordship, the petitioner all along posted at an interior village called Pomching, bordering to Myanmar. To travel from Mon to Pomching, it takes almost a day. It is not that the petitioner is attending the headquarters at Mon regularly. No, Lordship. All along, he was posted at Pomching village, bordering to Myanmar. And he used to visit the headquarters in when called by the officers only. Therefore, Lordship, The objection in the argument by the respondent summon into affidavit is baseless. And my cases, Lordship, I have made a specific statement that I was not aware about the promotion of respondent summon. He is saying that he should have known because some colleagues have been promoted. Who is he to make such a statement, Lordship? I'm saying I was not aware. I didn't see that. I was fully aware about the promotion. Your Lordship, the objection raised by respondent number 7 with regard to delay and approaching this court is baseless. And this is not an application for condonation of delay, Lordship. This is a writ petition. This is not an application for condonation of delay. Under the Petition Act. This is a writ petition.
Yes.
Therefore, Lordship, I'll rely only on two short judgment with regard to delay.
Well,
Paragraph 47 and 48 at page 755.
yes.
Paragraph 47 and 48.
Yes.
47. I tell you, say so, say to. Do agree with the Gauhati and leverage and future case. Noted that no period of limitation has been prescribed for filing a petition and then and proceeded to observe. Therefore, the question is one of the exclusion for this court to follow from the case. There is no more limits and there is no upper limit. A case will be brought within the limitation by reason of some articles, but this court need not simply take time to litigate remove this court or article 2. Similarly, in a suitable case, this court may entertain such a petition even after lapse of time. It will all depend on what the breach of the fundamental rights and the remedy claim are weighed out the errors. The issue of the opposite decision is that even though there is no petition for filing petition under Article 32 and 26 of the Constitution of India, the petitioner should approach the court without loss of time. And if there is a delay, then cogent explanation should be offered for the same. However, no hard and fast rule can be laid down, or a straightforward formula can be adopted for deciding whether or not this court or the High Court should then related petition filed under Article 32 and 26 of the Constitution of India. And each case must be decided on its own facts. I've supplied two lost copies. Number one is 1998 at ACC. 1998 ACC. It is still the lost copy. The file. supplied in earlier occasions. Nineteen 98 ACC.
Yes.
Two-page order, Lordship. 1998 ACC 685. Paragraph 1. Married Lordship. Respondent was temporarily appointed police constable. He was posted at the residence of one of the Honorable Judge of the Allahabad High Court. There was a written complaint by the Honorable Judge about the misconduct committed by the respondent. A disciplinary inquiry was held. The inquiry officer recommended that the respondent be removed from service. At that stage, instead of posting a new order and the same proceeding, an order of termination simplicity was passed under the UP government temporary government servant termination 1975. An appeal was preferred by the respondent against the strict termination before the public service tribunal. The tribunal held that two, the questions and from in truth, the order was final and dangerous. Accordingly, the respondent claim petition was allowed and the order of termination was set aside. 1.5 years later, the respondent the state filed a writ petition in the High Court against the judgment of the tribunal, which was dismissed on the ground of failure. The High Court observed that there is no proper explanation for delay in filing the writ petition after 1.5 years. The present CLB is directed against the order. And again, the approach of the High Court is not justified. There is no time limit for filing the writ petition, Lordship. There is no time limit for filing. All that the court has to see is whether the laches on the part of the petitioner are such as to disable him to the relief claim by him. But the High Court addressed to examine the matter as if it was a case under Section 5 of the Limitation Act, 1963. Apart from the above, we do not think that the proceeding should be prolonged any further. I'm not reading the risk option. So this is with regard to sport as the late and approaching the court under Article 32. Next case, Lordship. Another judgment. Same principle, Lordship. Yes. Lordship has already said the principle with regard of determination of investor seniority. No dispute. The petitioner is senior to the respondent. Therefore, the immune seniority list is totally arbitrary and elected, which is liable to be satisfied. Second issue, Lordship, the recommendation of this is total evaluation of the principle laid down and depth of case. Because the remarks was never completed. And the TBC was held in violation of the provisions of the Crop Service Law, particularly the provisions of Rule 7 of the Constitution. Therefore, Lordship, entire action from the provision of the tentative senior bills to issuing of the tribunal order, the recommendation of the division is arbitrary, illegal, where the face of this honorable court is called for. As far as the objection raised by the respondent number 7 with regard to the alleges worship, I made a specific statement in the petition how I come to know about the tribunal order, as well as the abuse of this. There is no deliberate alleges. Had the petitioner knew about the promotion of junior officer, I would not sit idle, Lordship. Therefore, Lordship, the objection raised by the respondent, 7, with regard to delay and latches as no basis. So I complete my submission.
Yes. You're for respondent 7.
No, I'm for the state, my lord. May I please, Your Lordship?
Who is for respondent number 7? You please continue.
My lord, firstly, I'm relying on para 5, 6, 7 of my affidavit in possession, my lord. I'm relying on para 5, 6, and 7. My lord, to save time, I'm not reading the paragraph. My lord, my second submission, my lord. My second submission is in regard to delay. My lord. There is a delay. My lord, here there is delay in challenging the seniority list and the DPC. DPC or the notification dated 19/7/21. My lord, here seniority list was notified in the year 2018. And in that seniority list, there was notified that if there is any objection, objection should be raised by any aggrieved incumbent within 30 days. And if there is no objection, then the seniority will then finality. So on 18 in the year 2018, the first seniority list was notified. The private respondent number 7 has submitted the representation saying that the 2018 seniority list is incorrect. And basing on that complaint filed by the private respondent, 2018 seniority list was rectified in the November 2018. So after that, my lord, till date, and the seniority list was challenged only in the year 2022. There is a delay of 3 years, my lord. There is a delay of 3 years. And my lord, in the notification also, basing on that seniority list, 2018 November 2018 seniority list, DPC was set. And DPC recommended the incumbent to be promoted to the assistant commandant. And that is, it was recommended, it was seated on 15/7/2021 and notification was issued on 19/7/2021. And the writ petition was filed only on 14/11/2022. There is a delay of more than 1 year. And my lord, representation was submitted only in the year 2022, that is 12/9/2022. So in my second point is, after a gap of 3 years, the petitioner is challenging the seniority list, and after a gap of more than 1 year, challenging the DPC recommendation. Secondly, my lord, thirdly, in regard to determination of seniority, my lord, determination of seniority of promotees. In there is a law settled that to determine the seniority of promotees, it should be from the date of joining. I have a citation. Your Lordship, to supplement my submission, please allow me to submit my citation. Para 9. Roshan Valley said Para 9.
Para 9.
Yes. Para 9. Para 9, subclause 5.
Yes.
5. Determination of seniority of promotees. Clause 1. Seniority of person appointed on promotion to any post, grade or cadre or grade shall be determined from the date of joining such post, grade or cadre or grade. My lord, by common order, both the petitioner and the private respondent were promoted to the post of assistant commandant by common order. So since they were promoted in the same post on the same day, so date of joining is to be determined. So basing on this, as per the, if it is called by the date of joining, the private respondent is senior to the, because he joined, private respondent joined on 25 and petitioner was joined on 26. So one day prior to the petitioner, the private respondent has joined. And my lord, in regard to non-consideration in the DPC, my lord, the petitioner has submitted that he was not aware, my lord. He was not aware because in the DPC, his case was not considered, despite of notice issued to the petitioner. On 1st April 2021, notice was issued to the head of the department, that is the DC, and notice was issued to the through the HOD, but the petitioner has not submitted his APAR. So those incumbent who has submitted the APAR, their case was considered. That is why in the DPC recommendation, in his column, there is blank. There is no remark. So now the petitioner cannot say that he was not aware, because notification was issued, notice was given to the petitioner. He himself, he has not complied the notice. And my lord, in regard to delay, my lord, delay, I have already submitted that there is a 3 years in challenging the seniority list and 1 year, more than 1 year in challenging the notification. Kindly allow me to place the citation note. Para 9. May I read the motion? Para 9.
Yes.
Although security of service cannot be used as a shield against administrative action for lapses of a public servant, by and large, one of the essential requirements of contentment and efficiency in public service is a feeling of security. It is difficult, no doubt, to guarantee such security in all its varied aspects. It should at least be possible to ensure that matters like one possession in the seniority list, after having been settled for once, should not be liable to be reopened after lapse of many years at the instance of a party who has, during the intervening period, chosen to keep quiet, racking up all matters like seniority after a long time is likely to result in administrative complications and difficulties. It would therefore appear to be in the interest of the smoothness and efficiency of such that such matters should not be given a quictus after lapse of some time. My lord, earlier I have submitted that 2018 seniority list was challenged in the year 2022. After a gap of 4 years, more than 3 years. More than 3 years. So basing on that seniority list, DPC was said And this DPC has already taken the decision. And that decision also challenging after gap of 1 year. So if that decision is driven, there will be a administrative complication. So my submission is basing on those three submissions. The petitioner has not make out the case, and the petition is liable to be dismissed on that ground. That is my submission.
Yes. Yes.
These rate conditions are decided on the meetings and reports. I'd like to take your lordships to that. My affidavit. Paragraph 4, important paragraphs are paragraph 4, 6 and 8. Your lordship. And the replies to that filed by the respondents the principles of law as laid down by the honorable Page 2 of my affidavit in opposition. Paragraph 4.
Yes.
That with regard to the statements made in paragraph 6 and 7 of the petition, the deponent respectfully states that contrary to the petitioner's unsubstantiated averments against the tentative seniority list of superior measures notified by the memorandum number so and so dated 14/9/2018, which invited submission of any objection, correction, clarification within 30 days from the date of issue of the memorandum. The deponent submitted representation dated 26/9/2018, praying for rectification to the effect that he should be made senior to the petitioner on the ground that upon promotion to the post of superior major, he joined his posting on 25/10/2016, while on the other hand, the petitioner joined his posting only on 1/11/2016. Thus, subsequently, the corrected tentative seniority list as on 15/9/2018 was modified by memorandum number so and so dated 30/11/2018, wherein the deponent is reflected as senior to the petitioner. Here, it may be noted that the petitioner did not challenge the validity of the memorandum dated 30/11/2018, and the same became final. So, subsequent to the first 2018, 14/9/2018, the petitioner submitted a representation, which is at annexure 4 at page 14 of the page 14, your lordship.
Yes.
This is the representation which I submitted against the tentative seniority list.
Yes.
And based on subsequent to this, the revised tentative seniority list was brought up, your lordship, which is at page 14, page 14A, your lordship, page 14A. Sorry. Page page 15, your lordship. This is the
In page 14A list, your name is in serial number?
It's at serial number 7, your lordship.
Serial number 7.
And the respondent was made.
And the petitioner's name is
the petitioner.
serial number 8.
Yes, petitioner is at respondent, we have serial number 8. And the memorandum, the memorandum by which this was issued is at page 15, your lordship. Page 15. Annexure 5.
Yes.
This is dated 30th November 2018. So in continuation of the office memorandum of even number dated the 14th September 2018, final command seniority list of superior measures of all districts under village park organization is prepared and enclosed as annexure 1. So by this, the revised interim seniority list was issued. That is on 30th of November 2018. Now, as the uh, 12th of November 2022, which is almost 4 years, only a few days. It is almost 4 years. The petitioner was sitting over the matter for all these 4 years. Now, in the meantime, of course, if nothing had happened in the meantime, then him approaching this honorable court by way of the writ challenging the seniority list would have been okay. But in the meantime, what happened? Right occurred to me, so I was promoted based on the seniority list, which was issued on 30th of November 2018. Now, and by the order, your lordship will see here. By the order, I'll take your lordship to the order which is at annexure page 24. Oh, I'm sorry, page 25. Your lordship. Yes. Page 25, this is July 2021, your lordship. There are 3 persons promoted. The petitioner, the respondent, the present respondent, I am the serial number 3. These 2 others, 1 and 2, they are both from the same tribe as the present petitioner. They are from Mon, but specifically the serial number 2. They are posted at the same place. Serial number 2. All of us were superior majors. All of us. Now he was promoted together with the petitioner. Or the respondent, but the present respondent number 7, that is me. So now he has come forward that he was unaware of this. Till 2022 February. This was issued in July 2021. What was he doing all this time? That is the question. And he has not explained anything. Even to my statement, he has not made any replies. Now, your lordship, I'll take your lordship to the paragraph 6, your lordship. Paragraph 6. Paragraph 6, page 4. If I may read, your lordship. Yes. That with regard to the statement made in paragraph 9 of the petition, the deponent respectfully states that it is preposterous on the part of the petitioner to claim that he came across the impugned notification dated 19/7/2021 only in the month of February 2022. By the impugned notification dated 19/7/2021, 2 other officers, namely Sri E. Taiwan Konyak and Sri L. Chon Konyak, were promoted together with the deponent to the post of assistant commandant. And Sri L. Chon Konyak was promoted to assistant commandant Mon, where the present petitioner is posted, from the post of superior major Mon, the same place of posting as the petitioner. It is indeed interesting to note that the petitioner, who according to his government was expecting his promotion to the next higher post of assistant commandant, was not even aware about the promotion of his immediate colleague Sri L. John Konyak to the post of assistant commandant. This by itself speaks volumes of the motives of the petitioner. Further, the petitioner's averment that by the impugned order dated 19/7/2021, the deponent who is junior to the petitioner has been given promotion to the post of assistant commandant is denied. The memorandum dated 30/11/2018 clearly reflects that the deponent is senior to the petitioner in the seniority list. However, regardless of the seniority position of the petitioner and the deponent, the promotion in the instant case was considered in terms of the provisions of the Draft Service Rules 2014, under which seniority alone is not the sole criteria for promotion. For the promotion, the annual performance assessment reports and other relevant reports of 3 officers, namely the petitioner, the deponent, and Sri Devi, superior major, who fell within the zone of consideration, were considered together, and based on the overall rating, the performance case was approved for promotion by the TBC, which is evident from the proposal for promotion to the post of assistant commandant under Village Guards Organization, white dated number so and so dated 16/4/2021. As such, there is no illegality in the promotion of the Your Lordship, it's time for a break, Your Lordship.
Okay, you continue. I will hear you.
Your Lordship.
This is the last item. There is
Your Lordship. So it is very clear. Officers who were of the same rank as the petitioner, he is an officer. We are all officers. Assistant Commandant is a class 1 cadet. He is supposed to be vigilant. He must know his rights and must be vigilant about his rights. What happened? Here in his writ petition, he has projected a case in such a way that since the present respondent is in another district, that is Kifiri district, he had no awareness about his promotion. Whereas the promotion order, by the promotion order, 3 officers, and 2 of them are from his own district, and 1 is posted in Mont itself. He was promoted. He was blissfully unaware of that. And suddenly he came awake only in the month of February. This is preposterous. He is trying to make a case. But an officer like him should be aware of what is going on in the department. That shows his negligence, which in the judgments which I will be presenting before Your Lordship, it will clearly show. Now, paragraph 8, Your Lordship. Paragraph 8. This is the most important paragraph, Your Lordship. Page 6. Paragraph 8.
Yes.
That with regard to the statements made in paragraphs 13, 14, 15, 16, 17, 18, 19, and 20 of the petition, it is obvious that the same are contrived, being the consequence of calculated afterthought. It is difficult to comprehend from his statements that the fact that among all the superior measures of the village guard organization, he is the only one who was oblivious of the existence of the memorandum dated 30/11/2018. But of course, he was aware only about the existence of the memorandum dated 14/9/2018. From his admission that he was at least aware of the existence of the memorandum dated 30/11/2018, no inference other than that he had no option but to acknowledge his such awareness, purely to construct a foundation for filing the instant petition can be drawn. Incidentally also, from his statements, it can be inferred that till February 2022, he was unaware about the promotion of his immediate colleague Sri L. John Konyak, posted at the same station as he, who was promoted together with the deponent by the same notification dated 19/7/2021. Here also it is apparent that he had to construct a rough tale of knowledge so as to build his case about and to explain away the delay in approaching the Honorable Court. In his attempt to construct a broad narrative to justify his belated approach before the Honorable Court, he has created huge gaps that cannot be filled. His statements are not merely implausible but absurd. Rather than support his case, his narrative only exposes his, to put it mildly, incompetency as a responsible officer of the uniformed service. His statements imply that he is totally oblivious of everything that is happening in the department. He is serving as an officer. This amounts to gross negligence. Lack of awareness due to negligence is no excuse. Even assuming, but not admitting that he was genuinely unaware about the existence of the memorandum dated 30/11/2018, or came into knowledge about the notification dated 19/7/2021 only in the month of February 2022. Knowledge of the same from the very beginning must be attributed to him. Justice is served only to those who are vigilant. The petitioner is guilty of delay and laches in filing the instant petition. It is settled principle of law that the courts exercising public law jurisdiction do not encourage agitation of stale claims and exhuming matters where the rights of third parties may have accrued in the interim. The memorandum dated 30/11/2018 reflects a deponent in seniority above the petitioner. Had the petitioner been aggrieved, it was incumbent upon him to challenge the validity of the memorandum without any delay before any right accrued to the deponent. But he, having not contested the validity of the same, it became final, and in the interim, right having solidified and accrued the deponent was promoted to the next higher post of assistant commandant by the notification dated 19/7/2021. However, here it is reiterated that the promotion of the deponent having been considered in terms of the provisions of the Draft Service Rules 2014. Seniority alone was not the sole criteria for the promotion of the deponent. As a record revealed, even the case of the petitioner and another officer who fell within the zone of consideration for promotion were considered together with the deponent. And based on the merit of the overall assessment, the TBC approved the promotion of the deponent. There is therefore no infirmity in the memorandum dated 30/11/2018 and the notification dated 19/7/2021. Then, after more than a year of the promotion of the deponent, the petitioner has preferred the instant petition, including both the memorandum dated 30/11/2018 and the notification dated 19/7/2021, citing ignorance as the sole ground for filing the belated petition, which is no ground in the eye of law. The petition being suffering from gross delay and laches on the part of the petitioner, the same is liable to be dismissed with cause. Now, Your Lordship, I take your lordship to the affidavit in reply which I mean, the affidavit in reply to the affidavit in reply to the filed by the respondent number 7.
What is this? This one. Yes.
Yes, Your Lordship. It starts from paragraph 4. He has closed over the specific statements made by the governments made by me in my affidavit in opposition. Paragraph 4, I have made it clear that he cannot have been unaware because the officer concerned who is posted with him was promoted by the same order. He has not even made a mention of that. He has paragraph 4, page 2, Your Lordship, that with regard to the statements made in paragraph 3 and 4 of the affidavit in opposition, his deponent begs to state that the writ petitioner submitted his joining report on 26/10/2016, which fact is substantiated by the letter dated 2011/2018, produced by the state respondents in their affidavit in opposition, whereby the Deputy Commandant V.G. Mong submitted the authentication of joining report in respect of the petitioner to respondent number 3, stating that the petitioner joined as Subedar Major on 26/10/2016. Therefore, the petitioner has reason to believe that nothing in his joining report to the effect that the petitioner joined on 1/11/2016 has been subsequently made with the motive to make the petitioner too near to the respondent number 7 in the post of Subedar Major. The said noting is highly questionable and therefore the authorities is put to strict proof of such inaction. But be that as it may, the date of joining to the promoted post of Subedar Major cannot be a criteria for determination of interstate seniority between the petitioner and the respondent number 7, as per the settled principle of law. The relative seniority of persons promoted to various grades shall be determined in order of their selection for such promotion by the promotion committee. Moreover, it is a settled principle of service jurisprudence that in absence of any specific rule, the seniority amongst the persons holding similar posts in the same cadre has to be determined on the basis of the length of service and not any fortuitous circumstances. Therefore, conferring seniority to respondent number 7 based on the date of joining to the promoted post is contrary to the law and principle of seniority under service jurisprudence. It is pertinent to state here that from the statement and the enclosure made in the affidavit in opposition, it appears that a private number respondent number 7 submitted a representation against a seniority list dated 24/10/2016, praying for to make him senior to the writ petitioner based on the date of joining to the post of Subedar Major. It is respectfully submitted that if there is any objection to the seniority position in the seniority list, the authorities would have given opportunity against whom seniority is claimed. No such opportunity was given to the petitioner before rectification of the seniority position, and seniority position has been arbitrarily rectified solely at the behest of respondent number 7, based on his representation objection. It is stated herein that a said seniority list dated 30/11/2018 was kept undisclosed, and the petitioner was not aware of the same seniority list, which was discovered by the petitioner only after coming to know the impugned promotion order dated 19/7/2021. No reply to the specific statements which I have made in paragraph 4. He has not explained the delay and just a mere repetition of his earlier statement in his petition in simple terms. Now, paragraph 6. Paragraph 6. Even here also.
Yes.
Paragraph 6. That is with regard to my paragraph 6, which I had submitted. That the statements made in paragraph 6 of the affidavit in opposition. This deponent reiterates the statement made in paragraph 9 and 10 of the writ petition. It is stated herein that as per the proposal dated 16/4/2021 submitted by the Department for Promotion to the post of Assistant Commander, seniority was a primary consideration apart from other criteria. In the said proposal, it is revealed that the seniority of the petitioner and the private respondents has been arranged on the basis of the date of joining in the promoted post of superior major. It also appears from the proposal that no final seniority list has been placed before the TPC except the abstract of seniority position from the impugned seniority list 30/11/2018. Moreover, the APARS column of superior major, although in respect of other officers has been duly filled up, the APARS column in respect of the petitioner has been kept blank. Therefore, the decision-making process of the respondent authorities for promotion of respondent number 7 to the post of assistant commandant is vitiated by arbitrariness, discrimination, and illegal, for which interference of this honorable court is called for. Nothing, no reply. It is not actually a reply to my affidavit in paragraph 6. Now, lastly, paragraph 8. Same here. That with regard to the statements made in paragraph 8, 9, and 10 of affidavit in opposition, this deponent begged to state that the petitioner knew about the promotion of respondent number 7, who is junior to the petitioner. The petitioner would not keep silent when he is superseded by junior officer. However, as stated at paragraph 9 and 10 of the writ petition, the petitioner came to know about the impugned promotion order only in the month of February 2022. Immediately thereafter, the petitioner appraised the authorities about the illegal promotion of a junior officer, to which the authorities assured to look into his grievances. However, since there was no positive response, he submitted a representation dated 12/9/2022, praying for revocation of the promotion of respondent number 7. Moreover, the petitioner also sought the information through RTI from the authorities as regards the decision in promoting the respondent number 7. The authorities furnished the necessary information on 3/10/2022. In the meantime, the petitioner discovered the impugned seniority list dated 30/11/2018. Immediately on getting the necessary information and documents through RDI, the petitioner immediately approached this honorable court by filing this statement, instant writ petition. Therefore, there is no deliberate delay or latches on the part of the petitioner in challenging the impugned memorandum dated 30/11/2018 and impugned promotion order dated 19/7/2021. The entire action and preparation of the impugned seniority list, which was kept undisclosed, proposal for promotion to the post of assistant commandant made by the department has not been done in connivance with the respondent authorities and thereby misguided the DPC with wrong information. Therefore, the decision-making process starting from the preparation of the impugned seniority list and issuing the impugned promotion order dated 19/7/2021 is arbitrary, discriminatory, and illegal, for which the interference of this honorable court is called for. Lordship, no reply to my specific statements. Lordship, you ought to give the justification. There is no justification whatsoever, and he is trying to submit or verbally that he is posted there, and even those statements are not to be found in his petition or even in his affidavit in reply. those are statements which are just concocted and outside of the record. Since so many judgments have been submitted with regard to delay and latches, I'll also focus on two decisions with regard to latches and delay, and when it comes to rights of third parties are involved. The first one is 2011 5 SCC, 2011 5 SCC. Six zero seven. 11 paragraph starts. Paragraphs 46 to 54 and 64 to 68. Paragraph 46 to 54. Here, so many previous earlier decisions have also been referred to, Your Lordship. Page 627, Your Lordship, 627. Paragraph 46 onwards.
Yes.
627, if I may read, Your Lordship. Read delay and latches, the heading. 46. Delay and latches is one of the factors that requires to be borne in mind by the High Courts when they exercise their discretionary power under Article 226 of the Constitution of India. In an appropriate case, the High Court may refuse to invoke its extraordinary powers if there is such negligence or omission on the part of the applicant to assert his rights taken in conjunction with the lapse of time and other circumstances. 47. The Privy Council in Lindsay Petroleum Company versus Heard, which was approved by this court in Moon Hills Limited versus Industrial Court, and Maharashtra SRTC versus Palwan Regular Motor Service has stated. Now, the doctrine of latches in court of equity is not an arbitrary or a technical doctrine, where it would be practically unjust to give a remedy, either because the party has, by his conduct, done that which might fairly be regarded as equivalent to a waiver of it. He has waived his right, or whereby his conduct and neglect, whereby his conduct and neglect, he has, through perhaps not, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In either of these cases, lapse of time and delay are most material. But in every case, if an argument against relief, which otherwise would be just, is founded upon mere delay, that delay, of course, not amounting to a bar by any statute of limitation, the validity of that defense must be tried upon principles substantially equitable. Two circumstances always important in such cases are the length of the delay and the nature of the acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking the one course or the other. So far as it relates to the remedy. 48. In Amrit Lal Perry, CCE, this court took the view that if a petitioner has been so remiss or negligent as to approach the court for relief after an inordinate and unexplained delay, he certainly jeopardizes his claim as it may become inequitable with circumstances altered by lapse of time and other facts to enforce a fundamental right to the detriment of the similar claims of innocent third parties. Instead of Maharashtra versus Tikambar, this court observed that unless the facts and circumstances of the case at hand clearly justified the latches or undue delay, writ petitioners are not entitled to any relief against anybody, including the state. 50. In Sheikh Das versus Union of India, this court opined that the High Court does not ordinarily permit a belated resort to the extraordinary remedy because it is likely to cause confusion and public inconvenience and bring in it extreme new injustices. And if writ jurisdiction is exercised after unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience, but also injustice on third parties It was pointed out that when writ jurisdiction is involved, unexplained delay coupled with creation of third-party rights in the meantime is an important factor which also weighs with the High Court in deciding whether or not to exercise such jurisdiction. 51. It is in City and Industrial Development Corporation versus Kosu Artificial Iwantiwala 26. It is well settled and needs no restatement at our hands that under Article 226 of the Constitution, the jurisdiction of the High Court to issue appropriate writs, particularly a writ of mandamus, is highly discretionary. The relief cannot be claimed as of right. One of the grounds for refusing relief is that a person approaching the High Court is guilty of unexplained delay and the latches. Inordinate delay in moving the court for a writ is an adequate ground for refusing a writ. The principle is that the courts exercising public law jurisdiction do not encourage agitation of stale claims and excluding matters where the rights of third parties may have accrued in the interim. 52. Sri Ranjit Kumar, learned senior counsel for contesting respondents, invites our attention to the observation made by this court in State of MP versus Nanklal Jaiswal, wherein this court has stated, this rule of latches or delay is not a rigid rule which can be cast in a straight jacket formula. For there may be cases where despite delay and creation of third-party rights, the High Court may still, in the exercise of its discretion, interfere and grant relief to the petitioner. But such cases where the demand of justice is so compelling that the High Court would be inclined to interfere in spite of delay or creation of third-party rights would by their very nature be few and far between. Ultimately, it would be a matter within the discretion of the court. Ex hypothesis, every discretion must be exercised fairly and justly so as to promote justice, not to defeat it. 53. Reliance is also placed on the observations made by this court in Delhi Rohtas Light Railway Company versus District Board Bhojpur, wherein it is observed the rule which says that the court may not inquire into belated and stale claims is not a rule of law but a mere rule of practice based on sound and proper exercise of discretion. Each case must depend upon its own facts. It will all depend on what the breach of the fundamental right and the remedy claim are and how delay arose. The principle on which a relief to the party on the ground of laches or delay is denied is that the rights which have accrued to others by reason of the delay in filing the petition should not be allowed to be disturbed unless there is a reasonable explanation for the delay. The real test to determine delay in such case is that the petitioner should come to the writ court before a parallel right is created, and that the lapse of time is not attributable to any laches or negligence. The test is not as to physical running of time, where the circumstances justifying the conduct exist. The illegality which is manifest cannot be sustained on the sole ground of laches. 54. The relevant considerations in determining whether delay or laches should be put against a person who approaches the writ court under Article 226 of the Constitution is now well settled. They are, number one, there is no inviolable rule of law that whenever there is a delay, the court must necessarily refuse to entertain the petition. It is a rule of practice based on sound and proper exercise of discretion, and each case must be dealt with on its own facts. 2. The principle on which the court refused relief on the ground of laches or delay is that the right accrued to others by the delay in filing the petition should not be disturbed unless there is a reasonable explanation for the delay, because court should not harm innocent parties if their rights had emerged by the delay on the part of the petitioners. 3. The satisfactory way of explaining delay in making an application under Article 226 is for the petitioner to show that he had been seeking relief elsewhere in a manner provided by law. If he runs after a remedy not provided in the statute or the statutory rules, it is not desirable for the High Court to condone the delay. It is immaterial what the petitioner chooses to believe in regards to the remedy. So it is very clear. Paragraph second, the second principle. In filing, there should be disturbed unless there is reasonable explanation for the delay, Your Lordship. Number 4, next page, Your Lordship. No hard and fast rules can be laid down in this regard. every case shall have to be decided on its own facts. That representations would not be adequate explanation to take care of the delay. Representations cannot be an explanation, Your Lordship, for the delay. Now, paragraph 64. Paragraph 64, page 633. This shows about how the party failed to give reasonable explanation, Your Lordship. Page 633.
Yes.
Page, paragraph 64. In the present case, the respondents in the writ petition had raised a specific plea of delay as a power to grant relief to the petitioners. In our view, it was perhaps necessary for the court to have specifically dealt with this issue. It is now well settled that a person who seeks the intervention of the High Court under Article 226 should give a satisfactory explanation of his failure to assert his claim. At an earlier date, the excuse for procrastination should find a place in the petition filed before the court, and the facts relied upon by him should be set out clearly in the body of the petition. It is not been done in the instant case. An excuse that he was agitating his claims before the authorities by making repeated representations would not be satisfactory explanation for condoning the inordinate delay in approaching the court. If a litigant runs after a remedy not provided in the statute or the statutory rules, it cannot be a satisfactory explanation for condoning the delay in approaching the court. 65. On this issue, we have heard the learned counsel for the parties in great detail, since the immovable property rights of the parties are involved. In our considered view, there is no explanation, much less satisfactory explanation offered by the respondents in approaching the writ court after an inordinate delay of nearly 15 years from the date of the notification issued under the Evacuee Property Act for the delay from 1952 to 1955. The contesting respondents would only submit that they were not aware of the notification issued under the Evacuee Property Act. Same here. With regard to the seniority list, he is feigning ignorance. Since no notice was served on them, though a public notice was issued by the authority under the Evacuee Property Act. While explaining the delay of nearly 11 years from 1955 to 1966, they contend that they were in possession of the property and they were making representations before the authorities under the Evacuee Properties Act for redressal of their grievance. The delay after the orders were passed by the Settlement Commissioner in the year 1983 till the writ petition was filed in the year 1990. It is explained that they had moved the state government to suo motu revise the order passed by the Chief Settlement Commissioner, and since the state government returned their request, they had approached the High Court to issue directions to the state government to issue appropriate directions. In our considered view, at every stage, there was inordinate delay in approaching the authorities for redressal of their grievance. 66. As rightly commented by Sri Mukund, learned counsel, even when they approached the authorities, they were claiming wrong reliefs or incomplete reliefs. Even when they filed a writ petition in the year 1990, they did not choose to question the correctness of the notification issued under the Evacuee Properties Act, but was questioned by way of filing an amendment application in the year 1998. There is some merit in the submissions made by the learned counsel for the contesting respondents that the petitioners in their pleadings before a writ petition court had not even offered any explanation, much less satisfactory explanation in approaching the court nearly after 3 decades from the date of notification issued under the Gauhati Property Act. 67. It is now well settled that the power of the High Court under Article 226 of the Constitution to issue an appropriate writ, order, or direction is discretionary. One of the grounds to refuse relief by a writ court is that the petitioner is guilty of delay and laches. Inordinate and unexplained delay in approaching the court in a writ is indeed an inadequate ground for refusing to exercise discretion in favor of the petitioner's theory. The unexplained delay on the part of the petitioner in approaching the High Court for redressal of their grievances under Article 226 of the Constitution was sufficient to justify rejection of the petition. 68. That the other factors the High Court should have taken into consideration is that during the period of delay, injuries had occurred in favor of the third party, and the continuation of unexplained delay would affect the right of the third parties. We are also of the view that reliance placed by Sri Ranjit Kumar on certain observations made by this court would not assist him in the facts and circumstances of this case. While concluding on this issue, it would be useful to refer the observations made by the court in Municipal Council Ahmed Nagar versus Shah Hyder Bay, where it is stated that delay defeats equity and the discretionary relief of condonation can be had, provided one had not given by his conduct a go by to his rights. In the instant case, the petitioner has been sitting over the seniority list. He allowed it to go by. And 4 years elapsed. Then suddenly when promotion was granted to the present petitioner on the basis of the seniority list, now he woke up. But then he had to explain over the delay. So he chose to choose sometime in February as the day he came into knowledge. All the other things were ignored. He has made no explanation whatsoever about all those things. He's an officer who is supposed to be aware of what is going on, aware of his rights. He has been sleeping over all those years. And in the meantime, the third party, that is the present respondent, had acquired certain rights. And on the basis of that right, he was promoted. And even after he was promoted, after more than a year, promotion was in July of 2021. He has approached this honorable court by way of this writ on November 12, 2022, more than a year. He has come crying before this court, and now saying that he was ignorant of what was going on all those years. And now when the issue of delay in latches was raised by the present respondent, highlighting the facts whereby he could not have been unaware of those going on in the department, he has not even replied to that. He has given no justification. Without any explanations, Lordship, now how can he say that there is no delay in latches? There is deliberate delay in latches on the part of the petitioner. And now right has accrued to me, a third party. So in this case, that delay cannot be condoned. This petition ought to deserve to be quashed and set aside. Now one more to supplement this present judgment. I'll give one more. This is 2015 1 SCC. 2015 1 SCC. Paragraph 20. 2015 1 SCC 347. 347. Paragraph 20, Your Lordship. If Your Lordship may turn to page 362. Page 362. Paragraph 20.
Yes.
I'll skip the 34 onwards, but all this has been discussed by the principle on which it is based. 20. The court also quoted the following passage from Halsbury's Laws of England. In determining whether there has been such delay as to amount to latches, the chief points to be considered are: 1. Acquiescence on the claimant's part. Here there has been acquiescence. Number 2. Any change of position that has occurred on the defendant's part. I am the defendant. Change has occurred to me. In the meantime, he has acquiesced to my seniority. In the meantime, change has occurred by way of me being promoted. Acquiescence in this sense does not mean standing by while the violation of a right is in progress, but assent after the violation has been completed and the claimant has become aware of it. It is unjust to give the claimant a remedy where by his conduct he has done that which might fairly be regarded as equivalent to a waiver of it, or whereby his conduct and neglect, though not waiving the remedy, he has put the other party in a position in which it would not be reasonable to place him if the remedy were afterwards to be asserted. In such cases, lapse of time and delay are most material. Upon these considerations rests the doctrine of laches. 21. Holding that the respondents had also acquiesced in accepting the requirements, the appeal of UB Chal Nikam was allowed with the following reasons. In view of the statement of law as summarized above, the respondents are guilty since the respondents have acquiesced in accepting the retirement and did not challenge the same in time. If they would have been vigilant enough, they could have filed writ petition as others did in the matter. Therefore, whenever it appears that the claimants lost time or whiled it away and did not rise to the occasion in time for filing the writ petitions, then in such cases, the board should be very slow in granting the relief to the incumbent. Secondly, it has also to be taken into consideration the question of acquiescence or waiver on the part of the incumbent, whether other parties are going to be prejudiced if the relief is granted. In the present case, if the respondent would have challenged their retirement during violative of the provisions of the Act, perhaps the NICAM could have taken appropriate steps to raise funds so as to meet the liability. But by not asserting their rights, the respondents have allowed time to pass, and after a lapse of a couple of years, they have failed. They have filed writ petitions claiming the benefits for 2 years. That will definitely require the NICAM to raise funds, which is going to have serious financial repercussions on the financial management of the NICAM. Why should the court come to the rescue of such persons when they themselves are guilty of waiver and acquiescence? This judgment clearly covers the instant case. So it is a fit case where this honorable court should dismiss the writ petition with cost. With that, I raise my submission.
To reply to the documented parts. I was expecting at least, my little friends, to advance their argument on the question of law with regard to how the sustainability should be determined. For that matter, whether consideration of uncommunicated ECR is permissible. Oh, but they are silent. They are trying to jump up over the technicalities. What's the first thing? Which this abuse seniority list was issued in continuation of the earlier tentative list. This abuse seniority list was never published in Gazette. How can I know, Lordship? It was kept undisclosed, and I have made a specific statement that this seniority list was kept undisclosed. It was never published, never gazetted. Yes, it was. When seniority list is dated November 2018. But never published. How can I know, Lordship? And I made a statement that I came to know about the seniority list after I acquired information from through the RDI with regard to TBC. I made my specific statement. So where is the unexplained delay in challenging this MBO seniority list up to? I've explained. And now, with due respect to do the judgment referred to my little friends, this judgment, Worship knows, this judgment was rendered in pertaining to a movable property. The petitioner approached the court after lapse of 15 years. Land matter, Lordship, then issue. So, under that context, the judgment was with regard to delay approaching the court. Here, in my case, where is the delay, Lordship? Where's the unexplained delay? And the impugn promotion order, when it is that here? That impugn promotion order is the promotion of the respondent. It was not served to me because my name is not here. How should I know? And after I come to know about the promotion of private respondents, I approached the authorities verbally as well as summoning representation. Instead of justifying, verifying the position of law, they are coming into the technicalities. Let them justify the illegal action. Whether the private respondent number 7 should be the senior or the petitioner. Or for that matter, whether the recommendation of the DVC in the best of uncommunicated ACR remarks is permissible under the law. Let them justify. Instead of jumping into the technicalities. Therefore, Lordship, all the objection with regard to delay and approaching, there's no basis, Lordship. No basis. I've explained clearly in my petition when I come to know about the impugn orders, impugn memorandums, and the mandates of the case. Therefore, Lordship, the action of the respondents are where we see illegal, Lordship, arbitrary, and discrimination. Therefore, Lordship, judicial review under Article 226 of the Constitution now India lies with the discriminatory and arbitrary illegal action of the respondent. And direction may be issued to conduct a free TVC by sitting a state in question all the proceeding of the TVC. Okay.
Okay, judgment reserved. Last one. Thanks. What's not required? I have not. Now committee section, court 101. Hello. No. Court 101. Court 101. Court 101 is there. It's something like that. It's something like that. E E E E dot Hiba EHI. 7 lakh है ये ना